Upon completion of the arguments, my lord, there was a question, my lord, as regards whether the publication will be relevant or not. Well, that was troubling me. So I analyzed, my lord, the entire, my lord, scheme of the Act as well as, my lord, the 1967 rules, my lord. I made a very short note, my lord, on that point, my lord. But I'll just indicate, my lord. The condition is, my lord, if any of the respondents die, or if any of the respondent gives notice that he does not intend to oppose the petition, but this notice of not intending to oppose the petition has to be by way of an application. So, and no application, not only affidavit, that is stipulated in Rule 40.
Okay.
That is stipulated in Rule 40, read with Section 116 of the Representation of People's Act, my lord.
Correct.
And I say, my lord, here, insofar as the non-appearing respondents are concerned, the principles contained in Order 8, Rule 10, my lord, of the CPC will apply, because the rules also make the provisions of the CPC applicable, because it says, yes, it says that the trial has to be conducted in consonance with the principles contained in the Code of Civil Procedure, my lord. That is also there, my lord. I have indicated, it's a very short note.
Okay, I will go.
And there is one judgment also, my lord, delivered, my lord, in connection with an election petition. This is dealing with, my lord, when respondents do not file written statement, they have a right to cross-examine.
Okay, thank you.
Extremely grateful, my lord.
May I be permitted to mention a matter? My lord, I've been having a little bit of bad luck with, my lord, one injunction petition. It was to be taken up on the day, my lord, Mr. Bhaskar Sen, my lord, his demise, my lord, courts did not function. And thereafter, yesterday, my lord, it was adjourned till, my lord, 7th of August. My lord, 7th, I'm in some difficulty. I was wondering if I could request your lordship to prepone it to 5th. I'm mentioning upon notice to my learned friends.
I am there, my lord.
Which matter?
That is
the. It's an injunction petition in connection with the 12A leave has been
granted. The Tilok Bose learned senior advocate was, my lord, appearing in this matter, where our general application number 2 is for revocation of, my lord, the dispensation allowed by your lordship under section 12A of the Commercial Courts Act. My lord, may I beseech your lordship kindly keeps this matter under the heading to be mentioned so that dates can be fixed. We are also, my lord, led by a series of seniors whose
also there in the matter,
accommodation may be.
Mr. S.N. Mukherjee, but there might be some difficulty with the dates. If Mr. Shahab is agreeable, if it can be kept tomorrow as to be mentioned, then the dates can be fixed accordingly.
No, it can be kept and to be mentioned any day. Okay, that's not the issue.
Tomorrow, let it come tomorrow as to be mentioned.
I am so grateful. I'm deeply
May I have your lordship's kind leave, my lord, to mention, my lord, the Dhandaulat matter which your lordship has released, my lord, under the notion that it was not part heard. Your lordship, my lord, was hearing GA1 to GA6, barring GA3. Your lordship had, my lord, disposed GA1, GA7. GA5 was another matter lordship kept. GA6 is
GA6 kept pending.
Yes, GA6, my lord, was the matter which I beseech your lordship to kindly retain. There, your lordship, my lord, has raised certain queries to the fire department and the municipal authority. I'm mentioning under notice, my lord. These queries are, my lord, actually the queries from your lordship. It would, my lord, in my most humble submission, not be appreciated in equal length by any other judge. This is my humble request.
How this court can continue?
My lord, your lordship has kept it parted. Kindly have a look, my lord.
Your lordship, I am appearing for the defendant in this matter.
I'm sure my learned friend will not have any difficulty in this sense.
Your lordship has already heard the entire matter, passed subsequent orders in all the respective GAs. And since it was, as my friend rightly said, that there were reports to be submitted by the fire department, in spite of that, your lordship had directed on the last date that the matter be released from your list because the court does not have the determination. So I feel...
yes. So, Millard, he doesn't have any objection, as I can understand.
No, I do have objection.
Objection of the here. This is Millard. Here, Millard, I join issue because your lordship's, Millard, the roster which has come out regarding determination is very categorical that all the matters which are parted will be retained by the judge who was listening.
Correct. Parted, with regard to the parted, I already completed the delivery.
Millard, may I clarify here? GA6 was heard by your lordship on 2 occasions in great length. First occasion, your lordship directed the fire department to submit a report. They did that.
This matter is released, mentioned before the concerned court, get it released, assigned from the competent authority.
We can, and the shortcut is your lordship's.
Correct, but that is not good.
May I have your lordship's? No, direction is not necessary.
Correct. Already released, you take appropriate steps.
We will do that. We will.
Indeed, to mention an application on the order 13 is summary judgment. truth came up before your lordship. There were some defects, and thereafter, my lord, like defects have been cured. And I've taken out this application, my lord, for summary judgment, my lord. But may I give this to you?
For what? What you want?
There are admitted views.
Okay, then when the returnable date in your application?
But application was taken
I
up
don't
on,
think, ma'am, this court will fix any matter afterwards.
my
Till
lord,
September, I
any-
will not fix any
take a
further
lordship, my
matter.
lord,
I don't want to go after puja. Let whatever the fixed matter in the till
May
September,
I
let
give
it
this
be
slip, my lord,
complete.
any day, my lord, your lordship?
That,
my lord.
there is no. If you want, I will keep as a to be mentioned, but I will not fix for the hearing because already there are so many matters are pending for hearing and already fixed time to time.
My lord, may the matter be fixed as to be mentioned tomorrow.
What? Let it be in the list.
Yes, yes. Kindly.
List में लेके आ
I'm
जाओ.
grateful.
May I seek your
Now
lordship?
you have served the copy.
But the defendant has not appeared yet.
Not appeared.
No.
New motion में लियो.
May I seek your lordship's kind leave to mention this matter, your lordship, this for acceptance of my written statement, commercial suit beyond 30 days, within 120 days.
हाँ.
Your lordship, what had happened was that
When the writ of summons was received.
to the writ of summons, your lordship, I have not received it. Subsequently, I have written to the office of the learned sheriff with respect to when the same was served upon me. Your lordship,
Hmm.
the sheriff's report is that it was served upon me on the 28th of April. Your lordship, however, my written statement is affirmed prior to that because in the GA1, which was the injunction application, the plaint was annexed.
Hmm.
So on the basis of that, I've prepared the written statement. So it's affirmed as of 12th March 2025. Your lordship, however, because I could not lodge the writ of summons with the department at the time of filing of the written statement, your lordship, the same was not accepted.
Hmm.
Lordship,
So if the writ of summons is not lodged, how you can file the?
Lordship, subsequently we've obtained the writ of summons from the office of the learned sheriff, your lordship, but that is beyond 30 days. Lordship, I'm considering that I need to move an application to that regard. However, lordship, I am just
Okay, yeah.
leave.
Given liberty to submit the written statement in the department subject to acceptance in course of the day. You file today in the department.
My lord, may I crave leave to mention a matter? My lord, your lordship has passed an order on 22nd of this month. My lord, in that order, my lord, there are some typographical errors. My lord, I have submitted that my written statement is additional written statement is not affirmed. My lord, it has gone down as affirmed. My lord, and so my lord, I cannot affirm the additional written statement and file within the time given by your lordship. My lord, I'm praying for some extension of time and that my lord, that not affirmed be my lord, included in the order. My lord. My lord, in the last paragraph of paragraph number 2, my lord, it has been gone down as not affirmed, and in my lord's paragraph 6, my lord, it has been 1 week's time had been given to me, my lord, but my lord, that has expired.
Yes, you stated that 51, 52 you are affirmed.
Yes, my lord, but
then
it is not affirmed. I said
you submitted and the court has dictated the order in open court. You have submitted the with regard to the 51, 52 paragraph. You affirm the written statement in addition to the earlier statement. That's all you have said.
not affirmed. It was only stamp punch, my lord. My lord, there must be some mistake, my lord, but it was only stamp
And how
punch.
you persons are taking the after punching and after the affidavit you're taking the pleadings in your hand?
My lord, only punch, my lord, that was not affirmed because there was no leave of the court, my lord, on that day. So it was only punched on that day, and that is.
You have stated, madam. What can be done? Who is the other side?
My lord, I have already given notice, my lord.
To be mentioned tomorrow.
But may I be permitted to mention, my lord, may I be permitted to file this plaint, my lord? What has happened, my lord, the stamp paper has been taken in the name of my chamber senior, and I am the advocate on record. But leave may be granted.
Chamber senior?
Chamber senior Nilotion Gupta, my lord. Stamp paper has been taken in my senior's name, and I am the advocate on record. And I am seeking
What you want?
Seeking leave to file.
Leave to use the
Leave is granted to use the stamp paper which is purchased in the name of the senior advocate.
May I mention? May I have a lordship's kind leave to mention a matter, my lord? For drawing up of the complete order, I'm seeking a lordship's leave.
Which order?
Your lordship, order dated 21st July 2025.
But may I be permitted to mention another matter, my lord? Non-commercial contempt matter, my lord. What has happened, my lord?
Non-commercial content matter.
Yes, there was direction to. There was a direction to file documents in the contempt application, my lord. I have the documents are already in my hand, my lord. There was a direction to file the same before this court, but I have gone to the register original side. He has not taken it as the time limit has expired, but I am ready to submit the documents.
Matter appeared last Friday. It was not called.
Taken up, not taken.
It be appear in the list, but we have to see. Lordship will have to see what are the documents inside.
But there was no
in terms of the order which went up for an appeal. That matter.
Friday ko list kar. Friday list kar.
I had to put some precedent in the list on Friday. Okay, some precedent in it will call on.
Friday to be mentioned.
Friday.
No, you keep.
No, no.
You keep.
Around file nahi hai.
You keep the document with
Yes.
you. It will be listed on Friday as to be mentioned at 2 p.m. It will be taken. Let us see what.
Deep level.
2 p.m.
May I have my lord's kind leave to mention, my lord, item number 30 upon notice of
Item number?
30, my lord, of the commercial side, my lord.
Ah.
This is a matter that was mentioned yesterday at the time of rising, my lord.
Hmm.
My lord, by an order dated, my lord, 24th June, my lord, I was granted leave to come back with the, my lord, written statement, my lord, duly, my lord.
When you receive the return writ of summons.
7th April. I have the
My lord,
plaintiff's
we are within time. The
Ah.
time is going to expire on 5th of August.
Hmm.
But 29th, my extension application was kept, and my lord had directed me to come with the prepared written statement, my lord. Along with the written statement, my lord, we have also, my lord, prayed for a counter claim, which is, my lord, subject to the payment of 50,000 rupees court fees. At the time of making payment, my lord, of the court fees, my lord, the name of the defendant, my clients, is the prefix used is MS, Messrs, my lord. Oblique word has been, my lord, accepted by the department. So, because of the special character, my lord, the court fees is not being accepted online, my lord. This is the only difficulty. Kindly allow me to file this within time, my lord. And my lord, kindly grant me leave to file the court fees, my lord, within, my lord, a week, my lord.
In the commercial matter?
Yes, my lord.
So, let you are appearing.
No, no,
Yes,
no,
yes,
no,
my lord. I have the plaintiff, my lord.
Plaintiff.
for the plaintiff.
Let it become tomorrow as to be mentioned. To be mentioned, let the file come. I will.
30.
Item number 30.
30 kal to be mentioned. Me kar do.
I'm obliged.
Issue the notice. Is appearing. Na?
Yes, my lord. My learned friend is
Come
appearing.
tomorrow. I will see the file then only.
This is a specially assigned matter, my lord. I have an application, my lord, for substitution of the name of the plaintiff, my lord. The defendants were, however, appearing, my lord. Today, I don't see them appearing.
Yes.
This is a specially assigned matter, my lord. GS6 is my application for substitution, my lord.
GS6.
Yes, my
Yes.
lord. The name of the plaintiff number 2 has
Which for
changed.
the other side?
They were appearing, my lord. They're not here today. May I give them a notice and come back, my lord?
Serve the notice.
Very well, my lord. May I come
The
back?
notice of the GS6. I will serve
My
the.
lord, I have served them. They were appearing.
Hmm.
Today, they are not here. Let me serve a notice and come back, my lord.
Okay. The matter is listed as to be mentioned, as the matter has been specially assigned to this court. Counsel for none appears on behalf of the defendant. According, counsel for the plaintiff is directed to issue notice upon the advocate on record of the defendant.
Number 1, my lord. Defendant numbers 2 and 3 are not appearing, my lord.
Defendant number 1, informing the next date of hearing, and to file the affidavit of service on the next date fix. List the matter on 4th August.
Maybe 5th, my lord. 4th is the monthly list.
Fifth.
I'm grateful. I'm grateful.
Lordship, I appear on behalf of the plaintiff. Your Lordship,
Yes.
upon scrutiny of the plaint, there is an office report before your Lordship.
Huh?
Upon scrutiny of the plaint, there is an office report before your Lordship indicating certain corrections. Lordship, leave is required to carry out the corrections. That is it for which this is come up.
The matter is listed as to be mentioned on receipt of the report from the office of the London Master. It is found that on scrutiny of the plaint, the department has deducted altogether 7, 1, 2, 3, 4, 5, 6 defects. Counsel for the plaintiff prays for 2 weeks time to cure the defects.
Your Lordship, kindly makes it 3 weeks.
3 weeks time to cure the defects. Affidavit, reaffirmation,
Yes, Your Lordship, we have to carry out a reaffirmation and re-verification.
and also prays for leave to re-verify and reaffirm the affidavit of the plaint. In view of the submission made by the counsel for the plaintiff, plaintiff is directed to rectify the defects and to re-verify and reaffirm the affidavit of the plaint within 3 weeks from date.
Grateful, Lordship.
On completion of all the formalities, the plaintiff is directed to immediately take steps for lodging writ of summons.
Grateful, Lordship.
This is appearing as for presentation of plaint,
Hmm.
but this really we should have been before the master. The only reason why this was sent to this honorable court is, my lord, if your lordship sees the name of the plaintiff, it here this suit is being filed by the insolvency resolution professional on behalf of the plaintiff, because plaintiff has gone into CIRP.
Okay.
That is why, my lord, it was sent. Otherwise, the defendant is within. Really, no leave is required. Your lordship would see the plaint. We have not prayed for any leave. And it's a non-starter report, so 12-day leave is also not required. We have annexed the non-starter report.
Okay.
But the only difficulty, my lord, I do not wish to present the plaint today because, my lord, I find there's an error in the affidavit portion. If your lordship kindly takes a look at, my lord, page 19.
Yes.
But I don't think it's been affirmed or verified in a correct way. Your lordship would see the paragraphs 1 to 23, 26, 27 have been affirmed as true to knowledge. So this is the resolution professional who is affirming. I do not think I should be presenting with this. I told my learned advocate on record, my lord, that if your lordship kindly grants leave to correct this or re-verify or whatever, my lord, then we can come up with that correction incorporated and then trouble your lordship or the master, my lord, because otherwise there is no impediment really to present the plaint before the master.
The matter is listed as to be mentioned on the prayer made by on receipt of the report of the London Master and Official Referee of this court dated 24 July 2025. Though the plaintiff has not prayed for any leave in the present plaint, but the master has referred the matter to place the matter before this court on the ground that the plaintiff has filed the suit through the interim resolution professional counsel for the plaintiff submitted. The plaintiff is in CIRP, and as such, the resolution professional was appointed, and on behalf of the plaintiff, the interim resolution professional has filed the present suit. So, counsel for the plaintiff further submitted there is defect in the verification in the affidavit portion and prayed for leave to re-verify and reaffirm the affidavit portion of the plaint. In view of the submission made by the counsel for the plaintiff is granted liberty and granted leave to re-verify and reaffirm the affidavit of the plaint within a week. And after reaffirmation, the matter may be placed before the master for admission of the plaint.
Lord, this is my plaint for price of goods sold and delivered, my lord.
Yes.
As the defendant is within jurisdiction, I was praying for dispensation of 12A, my lord.
12A?
Yes.
Why?
Well, the suit contemplates urgent interim leaves. The application is ready, my lord.
What is the suit for?
Suit is for price of goods sold and delivered.
From which date it is due?
Lordship.
From which date is it due and payable?
15. Around 51,85,000. It's due from, my lord, April 24 to July 25.
Correct. So what is the urgency?
Urgency is, my lord, that the defendant is, my lord, isn't they're not in a position to, my lord, pay off the debt. And, my lord, there are substantial debts which have been established by, my lord, the other purchasers as well, my lord. So in light of, my lord, the financial condition of the defendant, my lord, the urgency is, we are also praying for Order 38 Rule 5 reliefs in the application. On that basis, my lord, we are praying for, my lord, leave to praying for leave for dispensation of 12A, my lord. The application is ready, my lord. Upon presentation,
that's correct. Where is the ground for 12A, sir?
The ground is in the application, my lord. No, after Lord, the Sujata Manohar judgments and Yamini Manohar and everything, it's now just contemplation.
Now the new judgment, what is the name?
Well, Patil Automation is
not Patil.
The last one is Yamini Manohar.
No. Latest now. It is Dhanbad Fuels.
Dhanbad Fuels, my lord.
Go through.
The suit contemplates, my lord, it's there.
But go through. There are 7 parameters have been given.
Well, that is post.
Considering the Yamini Manohar and Patil Automation. Please go through. I don't think so.
Very well, my lord. We'll do the full.
What do you want?
Lord, she keeps it in the. I'll just
not
come
today,
back.
not today.
Not today.
That is also from our court.
Yes, sir, that's from our court. Wait.
I will split,
Yes.
on the section 12A, I'd factually, I'd shown that the plaint itself shows that they were aware of it since July, and in September it was served on them. That's rather the petition, because plaint we didn't have a copy. The section says it contemplates urgent relief. Now the contemplates has to be read in consonance with the cause of action itself. It can't be that your cause of action will arise before, and then when you want to file the suit, you'll say, now I'm contemplating urgent relief. So the fact that there was a question of the Supreme Court directing us to collect the money is not a cause of action for them to come, because they are aware. If their case is that they are supposed to get money under their agreement of 2012, and they are aware that arbitration has happened, they are aware that award has been passed, they are aware that section 34 has been dismissed, they are aware that appeal has been dismissed. So all that they are aware from July. Now, I just want to cite, I had the list of judgments were all there, but I think Dhanbad Fuels is the last judgment, which if we just look at the Dhanbad Fuels. This is 2025 SCC online, SC 1129.
Yes, it is here.
Mulad has a copy, correct. Kindly look at paragraph 62, because I'm sure Mulad has considered this judgment several times. I just want to show the conclusion, and
Clause F.
Yes. In light of the aforesaid discussion, we summarize the fundings as under.
Clause F.
Correct. Is of an examination of the nature and the subject matter of the suit and cause of action. The prayer referred urgently by the plaintiff could be said to be contemplatable when the matter is seen from the standpoint. So it has to relate. It's not. Therefore, when I showed in the IAGA 1, that paragraph where they say, page 18, paragraph 20.
Of the plaint?
Of the petition. We don't copy that. We still don't have a copy of the plaint.
Paragraph?
Paragraph 20, page 18.
Yes.
It sees dates given is sometime in July 2024. Surprised to receive a notice from Learned Mediation Center, High Court, Calcutta, mediation of commercial dispute filed by respondent 189 against the petitioner and the respondent numbers 2, 4, and 6. Recall, petitioner and the respondent number 2, 4, and 6 had that agreement where they said they're going to give us money in 2012.
Correct.
Then 21 upon receipt answered. Then 22, as no further notice was received from the Learned Mediation Center, petition instruct advocate check and update on whether any suit has been filed against the plaintiff. Upon inquiries made by the plaintiff's advocate, petitioner was made aware of an order dated 4th August 2024 of the Honorable High Court, Calcutta, in AP number 388 of 2024 and AP number 389 filed by the defendants for setting aside of an arbitral award made in connection with disputes and differences arising out of the SPA. Copy of the order dated 4th August 2024. Upon perusal of the order dated 4th August 2024, petitioner came to learn for the first time of arbitral proceedings initiated by the defendants in connection to the SPA. This is one of the original SPA where I was to get shares. However, none of the parties to the arbitral tribunal gave notice thereof to the petitioner, in spite of being fully aware of the fact that 18% total share in the respondent 1 were assigned to the plaintiff. In these circumstances, petitioner addressed an email dated 11 September 2024 to the respondents 2, 4, and 6, copy whereof is annexed here too. The respondent 4, paragraph 25, it's letter day 18 September, replied to the plaintiff's email dated 11 September 2024, along with which it forwarded a copy of an application being AP number 388, copy of the plaint being CS number 764, contents of the letter dated 18 September incorrect, denied, and copy thereof is annexed here too, marked as annexed here. Copy of the award dated 29 June 2023, which was annexed to AP number, such is annexed here too and marked as annexure L. Copy of the plaint being such is annexed here too and marked as annexure. Then from the cost papers of CS 764, petitioner came to learn that the defendants have falsely alleged petitioner has not made full payment of the consideration for 18% shares of respondent 1. Petitioner states among the payments, all the payments made by petitioner have been admitted by the defendants falsely alleged that only respondent 4 and 6 have paid the full consideration in terms of SPA. Allegation made by defendants are false and incorrect. True states.
Yes.
Well, July, August, and then September, they are aware.
Yes.
And this suit is not filed till May. May 16. Sorry. May 16, 2025. Well, no reason why the urgent relief will be divorced from the cause of action in this case. So in terms of Dhanbad fuels and all the other judgments, there has to be a correlation.
Yes.
We have the other judgments, so everything is considered in Dhanbad fuels. I think Patil and Yamini
both have considered.
All considered. That's I think the last pronouncement of law. On that ground, I'm saying it's mandatory. It's a suit instituted after 2022. The section 12 should be leave should be. Those are our submissions for it. I'm grateful, May I have my lords leave for just for 10 minutes.
Thank you.
Kindly have their application. Protracted arguments have been advanced, but I don't think any such case has been made out in the application. Kindly have GA3, please,
GA3?
Yes. This is their application. This is subsequent to an GA2, which is their application in under section 8. Kindly have their application. So the affidavit in support of the judge's summons. Master's summons. Lordship has the application?
Yes.
Prayer 5, my lord, paragraph 2 sets out the reliefs sought in the plaint.
Yes.
You kindly see paragraph 3. It's a very short affidavit, my lord. Kindly permit me to place this. I say that the said suit appeared in the list on 16th May 2025 when the Honorable Court was pleased to record, in view of the urgency pleaded on behalf of the petitioner, the matter was taken up for hearing. It is pertinent to mention that the plaint was affirmed on 14th and filed before this court on 15th. I state that the only urgency pleaded by the petitioner is as follows. The defendants and each of them are invading and are threatening to invade the right of the plaintiff. Invasion is such. This is, my lord, their understanding of my pleading. Then I say that the plaintiff failed to provide any ground or reasons for dispensation of pre-institution mediation under section 12A. The plaintiff has not pleaded any urgency at all. In fact, when the matter was made returnable on 20th May, the Honorable Court was pleased to record, without prejudice to the rights and contentions, this is, my lord, the order of the court. I'll place the order of the court. Then, my lord, kindly come to 7. I further state that false statements have been relied on by the plaintiff under affidavit while seeking dispensation under section 12A. The plaintiff has stated that the petitioner has instituted the above suit after obtaining leave under clause 12A, dispensation so-and-so. It appears that the affidavit, that such affidavit was affirmed on 14th May 2025 when the plaint was yet to see the light of the day. No affidavit is required to be filed. No affidavit is filed. This is the affidavit in GA1. So this, my lord, is neither here nor there when deciding GA3. Then I say that since the plaintiff has agreed to an availed mediation after institution of the suit, kindly see, my lord. I state that since the plaintiff has agreed to an availed mediation after institution of the suit, it clearly reveals there was no urgency on the part of the plaintiff. This mediation was pursuant to an order of court, a suggestion of court. Even otherwise, the plaint is not maintainable in its present form. The applicant has already taken out an application under section 8. Petition is without prejudice. So kindly make a note of paragraph 8, mediation availed of by all parties at the suggestion of court, unsuccessful. Then kindly come to 9.
What has happened to the mediation?
My lord, one meeting was held. The second time they said we will not involve the mediator, we will sit ourselves. The mediator has filed a report, my lord, no settlement. So mediation done. Mediation done, and this is the second round of mediation. I'll show you, lordship. There was a previous round of mediation where they didn't even bother to attend. For the same subject matter, yes, we'll see from the records. Then kindly come to the suit. Kindly see now paragraph 9. I say that the suit filed by the plaintiff is vexatious, harassive, and to arm twist. Plaintiff has filed the instant suit by the strength of an arbitration proceedings filed by the applicant. The award was made in favor of the applicant. Thereafter, the respondents and the applicants filed application under section 34 being so-and-so, which both ultimately got dismissed by a judgment dated 4th September 2024. Doesn't end there. This is the 34 dismissal of these two parties to which I am not party. And he says, I was not even required to be impleaded in the arbitration. Then kindly see paragraph 11. The respondent and the applicants, both in the said arbitration proceedings, preferred an application under section 37 of the Act being numbered as so-and-so respectively. Now kindly see the date of dismissal. Such application was also dismissed by judgment dated 5th March 2025. So the award, my lord, has not attained finality, at least till 5th March 2025, because both parties assailed the award. The plaintiff has relied on an order dated 4th August 2024, whereby the petitioner states that it was the first time the petitioner had knowledge of the arbitral proceedings initiated by the defendants. Pleadings and annexures state otherwise. Although the plaintiff pleads that the date of the relevant order is on 4th August 2024, the annexure shall reveal that the order was passed on 4th September 2020. This was a typographical mistake. I've clarified this in my opposition. So it's not August, it's September. And it is a proceeding to which I'm not party. It's an arbitration. It's a challenge to an award to which I'm not party. And I have knowledge for the first time after 4th September when I see the order from the portal of the court. But this proceeding between the parties does not attain finality till 5th March 2020, till 5th March 2025. The award is still under challenge by both sets of the defendants here.
Yes.
Now, my lord, so August and 24. Then kindly see, thus it is evident that the plaintiff has admittedly approached this honorable court at a much belated stage and thus is not entitled to any relief under 12A of the Act. The applicant states that such statements is incorrect since record shall know that the plaintiff. Now, my lord, kindly see, very interesting. The only case which is made out is this without any proof. The applicant states that such statement is incorrect since records shall reveal that the plaintiff had knowledge much prior to August 2024. What is the record? We don't know. He says this is a false statement which I have made. He says records will reveal no records annexed to the application, no argument advanced on this score. And all arguments which have been advanced are outside this application. And your lordship has been pleased to hold that arguments advanced from the bar are of no consequence. Then, my lord, kindly read further. Thus, it is evident that the plaintiff has admittedly approached this honorable court at a much belated stage. Then, paragraph 12 suffers from institutional defects. 12A leave should not be granted. Then, kindly see 13. Kindly see the duplicity of the stand of this petitioner, my lord. In the aforesaid facts and circumstances, since admittedly there is no ground. Now, kindly see, he says plaint not served. He's told your lordship thrice that plaint is not served. Kindly see paragraph 13. In the aforesaid facts and circumstances, since admittedly there is no ground for urgency made out in the plaint. So obviously he's taken inspection of the plaint. Either he's lying on oath here or he's lying from the bar. One of the two. To dispense with pre-institution mediation ought to be revoked and the parties ought to be sent to mediation for resolving their disputes amicably by rejecting the plaint filed in the instance suit. One round of mediation at the instance of court has already failed. I state that the plaint filed, now kindly see, 14. I say that the plaint filed by the plaintiff has not disclosed any grounds for urgency or interim relief. It does not contain a single averment with regard to the urgency or dispensation. He says plaint not served, but he makes allegations on oath of the plaint not disclosing grounds. Not once, but twice. I state that the order was obtained by the plaintiff by misleading the honorable court. Now kindly see 15. As the instance suit does not contemplate any urgent interim relief. Then the leave should be withdrawn, directions, etc., etc.
Yes.
So this is his application. Now your lordship will find from the 2 days of arguments which have been advanced, not a whisper of that in the application. Kindly, my lord, ignore all those arguments because they don't find any support in the application. But I will deal with them nonetheless.
Yes.
Now, my lord, kindly have the order by which parties were referred to mediation. Since it's part of this application, I'm not going chronology, but since your lordship has, kindly see page 13, please, my lord, annexure B.
No, when the leave was granted.
Leave was granted on the 15th or the 16th?
16th May.
16th of
page
May.
12.
Kindly give me a minute.
The order of 16th May?
Yes, 16th May leave was granted. So I'll just check, my lord. Either it's 16th or it's 15th.
This is a leave.
No. Kindly come. This is not the leave, my lord. The leave was by a separate order.
Correct.
This is when the GA-Com 1 was taken off. Perhaps leave was granted on 15th May. I'll just check.
ये plaint है क्या?
Plaint that day, my lord, it came up before your lordship for that defect report. So I think it's in the department, but I have a copy of the plaint. But your lordship's, the court's copy would have the fiat. But it was by the order of 15th May, subject to, I'll just check. Correct order, 16th May, my learned friend corrects me, my lord. It's part of the reply. Leave was granted. Kindly see the reply. Kindly have the reply filed in GA this GA3, my lord. Yes, 16th May.
Requirement, yes. Requirement.
Page 18.
Yes, good.
In view of the urgency pleaded on behalf of the plaintiff, plaintiff is presented and admitted subject to scrutiny by the department, etc. Leave was granted on 16. Application was, GA1 was also filed along with the plaint. So, my lord, now kindly see the order by which the parties were referred to mediation by the court. Kindly see page 13, please, of the application.
Yes.
20th May 2025. In view of the urgency, now, my lord, kindly see, in view of the urgency pleaded on behalf of the parties. Parties, not plaintiff. Your lordship has seen the order, first order, leave was granted. It's here, it's behalf of the parties, and I'll show your lordship why the urgency for everybody here. The matter is taken up for hearing without prejudice to the rights and contention of the parties. Now, kindly see, in response to a suggestion of the court, the three principal groups to this proceeding, represented by Mr. Mitra, who was leading me, my lord, Mr. Banerjee, who's appearing now, and Mr. Sen, who's for the other set of defendants, agreed to mediation to resolve their disputes and differences. So parties agreed that please don't make we can try to resolve in mediation. I was pressing for an interim order. The court said, no, you hold your horses, we'll have this matter resolved. And so the parties went to mediation. By consent of the parties, Mr. So-and-so is appointed as mediator. Then kindly see, but the court is alive to the urgency in the matter. Kindly see page 14. Let this matter appear on 10th June 2025 for hearing before the regular bench. Because this was, my lord, because this court, my lord, was on a circuit. So it was in the meantime. So 10th June is immediately after reopening of the court. In the meantime, so during the vacation, my lord, the parties are directed to exchange affidavits. Affidavit in opposition be filed within a week. Reply, if any, 1 week thereafter. So during the vacation, affidavits to be completed, the matter to be ready for hearing on reopening if the mediation fails. The question of the maintainability of the suit is left open. Liberty is granted to the plaintiff to file a supplementary, directed to file a supplementary, so and so. It is made clear that there has been no adjudication on the merits. All questions are left open, including the question of maintainability of the suit. Obviously, they said this is hit by 12A, this is hit by Section 8, also all questions of maintainability. But the court, even on this day, when referring the parties to mediation, at the instance of the court, was alive to the fact of urgency, and that is why directions were given. These directions, of course, flouted, my lord. 3 extensions were taken. Affidavits have been filed in July. Now, my lord, so all the arguments which have been advanced on the merits of the suit don't find mention in the application. Now, what is the suit about? Kindly have GA1. Since, my lord, this is the application, there is no GA annexed. The plaint, they say they made allegations about the plaint, but they don't bother to annex the plaint. Kindly have GA1 then, please, my lord. Kindly have GA1.
Yes.
GA1, your lordship will kindly see. Kindly have the cause title once, please, my lord. Because the array of parties will be evident from the cause title. I am the petitioner, my lord.
But Mr. Thakker,
please,
without going to the plaint, how the court can assert?
Your lordship will see the plaint. I have a copy for your lordship.
Because they are not.
Because they have made allegations on the plaint. I thought they will. On the affidavit, they've said plaint does not disclose. I've seen everything in the plaint, etc., etc. So I thought they would trouble your lordship with the plaint. এটা তো আমার লেখা আছে না কপি দাও plaint volume 1 record है I asked to get out in this thing. Kindly have the plaint once, please, my lord. I'll just না তোমার কাছে আছে তো সব Kindly have paragraphs 38 on.
Without the plaint, how you file the application under 12?
Strategy on the last day had indicated that the petition we thought.
This is, my lord, these are acts of desperation.
This is the first application I find
Without
the contents. How you can say that
Yes.
12A is to be revoked?
And he says the contents doesn't have. He says on oath that there's no content in the plaint.
You not enclose the
Even
plaint.
even if that, your lordship knows in party automation, the court can suo moto look into the plaint.
Court suo moto going to the plaint.
That is what the court is doing.
What the court has to do? Court has to read the plaint. What is the cause of action? When the
But
date of cause
problem
of
is,
action?
even since May 16 till date, they have not served a copy of the plaint. But they want to press for GA1.
Yes,
What-
after
no, 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 what
GA1 is allowed, then Order 39, Rule 3 comes in. After injunction, plaint and petition both are served. Let my learned friend read the law first. Kindly see the plaint now, my lord. Kindly see paragraph 38 onwards. My lord, I would have taken your lordship through the plaint after telling your lordship what the facts were. May I just tell your lordship what the fact? Kindly have GA1, please, my lord, because I have only one copy of the plaint. I'm sorry, my lord. Kindly have GA1.
काम करो, plaint मंगा लो. Yes, GA1 is here.
Production of the plaint. GA1, your lordship. My lord, kindly see the cause title once, please. I am the petitioner.
Yes.
Plaintiff is the petitioner. Now, my lord, defendant number 1 is the, if I may say, the target company or the asset owning company. The asset of the defendant number 1 is a leasehold interest, 99 years or 999 years leasehold interest in prime commercial property at 5 Jawaharlal Nehru Road, which is just on the intersection of the Esplanade crossing. 2 is Mr. Banerjee's client. 3 is the director of Mr. Banerjee's client. 4 is another company. 5 is the director of 4. 6 is another company. 7 is the director of 4. Now, my lord, company, the defendant numbers 2, 4, and 6 entered into an agreement with the defendant number 1 and the shareholders of the defendant number 1 being the defendant number 8 onwards. The object being to acquire the shares of the defendant number 1, so as to gain control of the defendant number 1 and thereby exploit the leasehold rights of the defendant number 1. So the idea was that they will become the shareholders and the commercial property which the defendant number 1 has, the leasehold right will be exploited by raising a multi-storied building, a new commercial building, commercial complex will be raised. That was the subject matter of the share purchase. Under the share purchase agreement, defendant number 2 was to get 36% shares of the defendant number 1. Defendant numbers 2, 3, 4, 5, and 6 and 7 approach me and say that defendant number 2 does not have the funds to acquire this entire 36% shares because they have to contribute. 82 crores was agreed to be paid to defendant number 1 and the outgoing shareholders of defendant number 1. So defendant number 2 would have to pay 36% of 82 crores.
So that the one dependent one get away.
So yes, so defendant number 1 remains, but the shareholders of defendant number 1 change. So the defendant number 8 onwards, they sell the shares to this. So defendant number 1 does not, defendant number 2 does not have 36% to pay. 82 crores ka 36% he does not have. So the other defendants approach me and say that you enter into a memorandum of understanding with the defendant number 1. You pay this amount, 50% of 36% is assigned to you. You will get 18% of these shares of the defendant number 1. Now kindly see the MOU once, please. Kindly have GA1 and kindly have the MOU which is annexed to GA1. Kindly come to page 80. This was shown to your lordship, my lord. Kindly come to page 80. A lot was said about the date of this, 21st June 2012. Page 80, please, my lord. Annexure C.
Yes.
So defendant number 2 is the transferor. I am the transferee.
Yes.
And the defendant numbers 4 and 6 are the confirming parties.
Yes.
Now, my lord, the narration of facts which I just told your lordship is there in these pages. I am not troubling your lordship with that. Kindly come to paragraph 3. I'm sorry, paragraph 2 at
So
page
this
8.
is the agreement of 21st of June
2012.
Between the Jagriti, defendant number 2.
Defendant number 2 and the petitioner, and the defendant numbers 4 and 6 are confirming parties.
Oh, yes.
Yes. Now, my lord, kindly see paragraph 2. To effectuate such assignment and transfer. So assignment, my lord, of the rights of defendant number 2 under the share purchase agreement. To effectuate such assignment and transfer, the transferor has agreed to cause to be transferred by the above named present shareholders, who are the other defendants in the suit, out of its proposed allocated shareholding, agreed to be purchased by the transferor from the present shareholders under and in terms of the said share purchase agreement, 18% of the total equity shares of the company held by the present shareholders directly in favor of the transferee by nominating the transferee to the present shareholders to complete the transfer of such 18% shareholding of the present shareholders in the company unto and in favor of the transferee. So he is to get 18, he is to nominate me to get 18%. Then kindly see the consideration payable by the transferee to the transferor for such assignment and transfer has been agreed to be 14.76 crores only, out of which rupees 3.60 crores shall be paid towards consideration of 18% of total equity shares of the company, and the balance sum of rupees 11.16 crores shall be towards 18% of the total loan amount agreed to be provided to the company under in terms of the said share purchase agreement. So under the share purchase agreement, my lord, the majority of the fund, that is 62 crores, was to be given as loan to the company itself, ostensibly, my lord, for clearing the encumbrances, etc. So this is how the money is to be paid. Then, my lord, it says how, kindly see now 3.1a, very important. See, the said consideration of 14.76 crores shall be paid by the transferee to the transferor as follows. 6.03 crores has been paid as earnest money before the execution of the agreement itself, on the receipt whereof the transferor doth hereby, as also by the receipt and memo hereunder, written, admit and acknowledge. And then it goes on to say how the balance money is to be paid. Now, my lord, kindly come to paragraph 7 at page 84. Clause 7 at page 84, please, my lord. In case the transferor is ready and willing to comply with its obligations herein contained, and the transferee, that is I, my lord, fail to make payment of the balance consideration within the period mentioned in so and so, the transferor, now kindly see, the transferor shall cause to be transferred to the transferee such reduced proportionate number of equity shares of the company on pro rata basis as be equivalent to the consideration amount paid by the transferee to the transferor hereunder. Example, in case the transferee pays 7.38 crores out of the consideration of 14.76, then the transferor shall be liable to be caused to the transferee proportionate 50% of the 18%. So I get 9%. I pay less money, I get less shares. And then kindly come to, so all these are there. I get less money, I pay less shares. Then kindly come to 8. In case the transferee is ready and willing to comply with its obligations herein contained, and in spite of the present shareholders completing the sale and transfer of the shareholding of the company in favor of the transferor and the confirming parties, the transferor fails to be caused to transfer the said 18% shareholding in favor of the transferee shall be entitled to sue the transferor for specific performance. Then kindly see 9, which is very important. In case, due to any reason, the said share purchase agreement is cancelled or terminated, the transferee shall be entitled to refund of the entire money until then paid by the transferee to the transferor. And now, my lord, kindly note when this is payable. Immediately upon the transferor receiving the same from the present shareholders and or the company, as the case may be. So a lot is said about cause of action. I ask myself this question: could I have instituted the suit for recovery of monies before he received?
After the award confirmation.
After the award is not only after the award is confirmed, after he receives the money. Before that, my suit is premature. Correct. I have no cause of action. My cause of action arises to get the monies from him immediately after he receives the money. He is not liable to pay me even one day before, my lord, the transferor, the company and the shareholders return to him the money.
Yes.
So this is one part of the cause of action. Yes. When did he receive the money? I'll show your lordship. He received the money after this suit. When we were in mediation, he goes and withdraws the entire money from court because there's no interim order.
When the amount was deposited in the court?
The amount was deposited in the court during the 34, my lord, pursuant to a 36 order. But it was only deposited, monies were not released. The monies were released only to pursuant of an order of the Supreme Court when the challenge attains finality. The challenge to the award
34.
Correct. The 34 is both parties 34.
Then
The 34 then 30 is the Supreme Court is still pending. But in the Supreme Court on 12th of May of this year, an order is made that he is entitled to withdraw the principal amount, the interest will remain. Once he gets an order to...
What is the date of the order?
12th of May 2025.
And when you file the suit?
15th of May 2025.
And where is the cause of action shown in the print?
Kindly, my lord, may I take back my copy if your lordship permits me? There are two causes of action, my lord. There are two causes of action. This is one cause. If your lordship kindly now has the reliefs claimed in the plaint once, please, my lord. Kindly have the reliefs claimed once in the plaint. Page 29. Declaration that the award dated so-and-so made in the arbitral reference between the defendants is not binding on and does not affect the right, title and interest of the plaintiff in respect of 18% shares of and in the defendant number 1. Pausing here for a minute, my lord. I say that this award which you have done, this arbitration which you have done between yourselves is not binding on me. I was not party to the proceedings. I was not given notice to the... Although my right to get 18% of the shares is affected. Yes. So it is only when the challenge to the award attains finality can I come to court. If the award is set aside in 34, the award is set aside in 37, where does my cause of action arise? If he gets the 36% shares, he's bound to give me 18%. Then my cause of action would be only against him for specific performance of the MOU only. That now you've got your 36% shares, now give me 18%. But the challenge to the award got decided only by the division bench judgment. And this is an award to which I'm not party. An award is binding only between the parties. It's not an action in rem. It's an action in personam. So your lordship has seen the agreement was assigned to me, the share purchase to the extent of 18%. That is why I claim that this award which you have done between yourselves is not binding on me. And now, my lord, kindly see prayer B is for damages. As a consequence of not getting, I had two remedies open, my lord. Either I could have sued for specific performance, to that you give me my 18% shares against all the defendants. But because of the passage of time and I am not aware of all this, I claim damages. That's an option which is open to me. So I seek declaration that the award is not binding on me, and then I claim damages. Then, my lord, kindly come to C. Decree for rupees 25 crores as stated in paragraph 34 above against the defendants and each of them. Now, what is this 25 crores? This is refund of the monies which I have admittedly paid along with interest. When is this money payable to me? Only when he gets the money from court or from the other defendants. In this case, the court, but under clause 9, when he gets the money from the other defendants. But I say, my lord, that all these defendants have colluded and conspired against me, and each of them is liable to pay this money to me. And Mr. Banerjee makes submissions that these are all friendly respondents. I claim a relief against each of them. Then, my lord, kindly see next. Kindly now see E. Perpetual injunction restraining the defendants from withdrawing any money deposited with the registrar original side of this honorable court pursuant to orders made in so-and-so without making payment of the plaintiff's claims as stated in paragraph 32 and 34. The money which is lying there, I am entitled to receive.
But now they are
now they've withdrawn. So this is, see the reliefs E and F. Because this is my money which is lying in court. And I'll show your lordship why this is my money. The amount deposited with the registrar original side of this honorable court pursuant to orders made in so-and-so be made over to the plaintiff in pro tanto satisfaction of its claim. Now, if the urgency is not contemplated, if there's no urgency, these prayers become redundant. If he withdraws the money and takes away this entire money, my suit becomes infructuous insofar as prayers E and F are concerned.
So now they have withdrawn. What would happen?
My lord, I will get, my lord, decree for money under C. And, my lord, I'll seek a mandatory injunction in my affidavit GA1 application that these monies should be brought back. Now, kindly see the urgency which is pleaded. Kindly come to paragraph 38.
Yes.
The defendant number 1 claims, that is, my lord, James, claims that it has already deposited rupees 26 odd crores in court pursuant to orders passed by this honorable court and thereby discharge its liability to repay the plaintiff. I'll show your lordship this suit because I said this is the second round of mediation. The first round of mediation was for this, before this suit was filed. the plaintiff is entitled to refund of the consideration paid by it from the monies deposited in this honorable court and to appropriate the same in pro tanto satisfaction of its claims stated in 32 above. However, the defendant number 2 is taking steps to withdraw this amount and has instituted EC number so-and-so for such purpose. The plaintiff is entitled to and claims perpetual injunction restraining the defendants from withdrawing any amounts deposited with the registrar pursuant to orders made in so-and-so without making payment of the plaintiff's claims, as stated in 32 and 34 above. Then, my lord, kindly come to 42. There is extreme urgency in the matter. By a I'm sorry.
Yes, yes, continue.
There is extreme urgency in the matter. By a letter dated 12th May 2025, the defendant number 1, I'm sorry, my lord, I mixed up the dates. Letter is of 12th May 2025. By the defendant number 1 has forwarded the order dated 9th May 2025 made in SLP number so-and-so, filed by it, from which it appears that the defendant number 2 has been permitted to withdraw rupees 19 crores 92 lakhs from the amount deposited in this honorable court. So 12th of May, I come to learn of this order of 9th of May. Then kindly see 43. The defendant number 1 has instituted CS number so-and-so between the parties after mediation has failed. Therefore, there is no prospect of mediation being successful. I'll show you, Lordship, what that suit was. That suit was that the monies which have been deposited in this court discharges D1 from all liability. I am entitled to part of this money. And therefore, he is not liable. Defendant number 1 is not liable to pay me any monies. Because that money which he is deposited, he has received from me. Then kindly see the defendant number 2 will take advantage of the delay caused by mediation and withdraw the monies deposited in this honorable court to defeat the claims of the plaintiff. This is what has happened. The plaintiff is entitled to urgent interim relief and shall seek the same by way of an application. The plaintiff seeks dispensation of pre-institution mediation.
Yes.
This is the urgency which is pleaded. Now, my lord, kindly come to GA1, please. Your lordship has seen what the MOU was and clause 9 of the MOU. I could not have filed a suit. My cause of action would not have crystallized insofar as recovery of money is concerned without him, my lord, getting the money.
Yes.
Then now, my lord, kindly come to page 87 of GA1, which is the memo of consideration.
'87.
Yes, please, my lord. Of GA1.
Yes.
Kindly see the memo of consideration. It recorded 6 crores 3 lakhs has been paid. Now, my lord, kindly see who is paying to whom. 1 crore, my lord, 38 lakhs I have paid directly to D1. He has not paid. 1 crore 38 lakhs I paid directly to D1. 4 crores odd, the balance I have paid to him.
One crore 20.
1 crore 20 plus 18.
18.
Both in favor of James Glendye, who's the defendant number 1. So I have made payments directly to defendant number 1.
Yes.
Now, defendant number 1 is returning my money by putting it in court. He takes it away.
Who has taken?
D2.
D2.
This is my money. It is not his money. This is my money which has been refunded by D1. And D2 takes it away. This is the whole malafide conduct of this respondent.
Yes, next.
Then this balance money I have paid to him. Now, my lord, kindly come to the CS 764, which is filed by, my lord, D1, the prior suit. And kindly see, my lord, what the subject matter of that suit was. Kindly have, my lord, GA2 once.
GA2?
Yes. I'm sorry, GA1, where the plaint of the previous suit is disclosed.
Page?
Kindly give me a minute, my lord. .232. Page 232, which is in volume 2. This is a suit which was filed after failure of pre-institution mediation.
Pending before this court only?
Yes, yes. This is in this suit, your lordship pronounced a judgment few days back that this very defendant had forfeited its right to file written statement. Jagriti had taken out an application for condonation of delay in filing written statement, which was rejected by your lordship. Kindly have page 232, which is the prior suit.
Yes.
Now kindly see who the parties are. James, who's defendant number 1 in my suit.
Yes.
Bhargava, who represents the outgoing shareholders, my lord. Plaintiff 2 and 3 in that suit is, my lord, defendant numbers 8 and 9 in my suit. Then kindly turn over. Jagrati Trade Services is defendant number 2 in my suit. Jagdish Sharda is defendant number 3 in my suit. Then kindly turn over. Goldsmith is another company of the Sardas, my lord. I am defendant number 4. And Orbit is, my lord, the defendant number 4 in my suit. Now, this is the suit which was filed. Now, kindly come to paragraph.
Orbit is D4, na?
D4 in my suit. Orbit is D4 in my suit. He is D4 here, D5 here.
D5.
Yes.
Performer.
Yes. Now, kindly come to.
Where is the prayer?
Yes, ma'am. Just 1 minute, please, my lord. Kindly bear with me for a minute. Kindly come to page 249. I'm sorry, paragraph 12 starts at 248. Kindly have 248. Before that, my lord, that plaintiff talks of the memorandum of understanding between me and D2. Now come to paragraph 12. The mode and manner of payments made by or on behalf of defendant number 1 to the plaintiff number 1 company and or the plaintiff number 2 are set out herein below. So he says Jagrati has paid. Now the chart A gives the payments made directly by D2 to D1. Then kindly come to page 249. Kindly see the last box at that page. Tirupati Vancom. Your Lordship has that? Payments made by Tirupati Vancom to James Glendye on account of loan. 4 crores 73 lakhs. I have paid directly to D1. He has not paid. I have paid. Then kindly see the next page, 250. Payment made by Tirupati Vancom on account of shares. 1 crore 84 lakhs 47,250. So this amount adds up to, my lord, in excess of 6 crores.
Yes.
And 4 crores I have paid him directly, which he admits in the MOU.
Yes.
D2. So 11 crores I am out of pocket. Now, my lord, kindly come to. I'm not troubling your lordship with all the award and arbitration, etc., which was filed between the parties. Kindly come to paragraph 25 at page 260. By an award dated so-and-so, Honorable Court was pleased to direct that the entire awarded amount of 26 crores be deposited with the registrar with directions being complied with, etc. High Court would consider the question of stay later. So it is pursuant to this order that they deposited the monies. All this is happening behind my back, my lord. Kindly come to paragraph 31 now. At page 262. I'm sorry, paragraph 29 first, please, my lord. Admittedly, a sum of rupees so-and-so has been paid by D3. I'm not D3. Now kindly see, a sum of rupees 6 crores 57 lakh 90,000 has been paid by D4. I am D4. I have paid 6 crores 57 lakh 90,250 to D1. I join issue with this part there, my lord, on behalf of D1. It's not on behalf of D1. The rights were assigned to me. It is on my own account. 6 crores 57 lakhs I have paid. Now, my lord, kindly come to paragraph 31. The plaintiffs, without prejudice to their rights in the pending application under section 34, have deposited the money with the registrar as per the directions of this court. Now, kindly see next line, very important. Such deposit discharges the plaintiffs from any liability in respect of the said sums to D3 and 4. So he says, I have already returned your money by putting it in court. You have paid 6.57 crores to me. I have returned 6.57 crores by putting it in court. And he prays for a declaration.
Yes.
And then he says, pray for a declaration. Now kindly see, in the alternative, plaintiff prays for a declaration that the award directing refund of a sum of so-and-so to the defendant number 1 is also binding on D3 and D4 herein, and the plaintiffs are absolutely discharged from any liability in such regard. So although I'm not a party to the proceeding, he sees a declaration that I refund money to D1, you're also bound by it. And now kindly see the reliefs which he seeks. Kindly come to page 266.
Yes.
A decree for declaration declaring the plaintiffs are discharged of all liability to D3 and D4 in respect of the payments of the amount of 69 lakhs and 657, which I am interested in, my lord, together with interest upon deposit of the same with the registrar original side. So he says, I have deposited the money. Now I'm not liable to pay you anything. Although I've received the money from you, I have deposited this money in court. Now I'm not liable to pay you anything more. Alternatively, a further decree of declaration that the award dated so-and-so is binding on D3 and D4. Award is not, I'm not party to the award, it's not against me. He comes and wants to make it binding against me. This is where the collusion between these two people is there. And he turns it around to say, I'm in collusion. Then, my lord, kindly see mandatory injunction, D. Kindly see D. He says, I cannot claim anything from him. In C, then D is mandatory injunction to have their claims against the plaintiff, because I have a claim against him for alleged advance made on behalf of D1 be entered and adjusted from the fund deposited with the registrar original side. This fund has gone now during the pendency of my suit. Now, this suit, my lord, was filed after pre-institution mediation. Notice was given to me. Notice was given to D2. D2 did not appear. If it had been resolved in mediation, I would have got the monies which I gave, that is 11 crores, 6 crores directly to D1, 4 crores, 35 lakhs admittedly to D2 in the MOU.
So the mediation notice which they are referring to this, again with regard to this case.
This case. This is the first mediation which happened. Before this notice came to me, my lord, I was not even aware of any of these proceedings. This is my clear case on oath. They are not able to show anything to the contrary. So, A, my cause of action did not arise. Now, kindly see the order which is made by the Supreme Court once, please, because your lordship wanted to see the order. Kindly see the order and the letter which has come. They told your lordship the letter is not on record, but it is at 346. Your lordship wanted to see the letter and the order. This is the letter of 12th May.
Yes.
We write in reference to the order dated 9th May 2025 passed by the Honorable Supreme Court of India and SLP so-and-so, where Jagrati, that is D2, has been permitted to withdraw the principal sum of 20 odd crores from the amount deposited by us with the registrar original side. Copy is enclosed. It is not disputed that a sum of rupees 6 crores 57 lakh 90,000 was paid by your company. This amount formed part of the total sum of 26 crores deposited by James in compliance with the directions of the court. Accordingly, having deposited the entire awarded amount, we have discharged our obligation in full with respect to all payments made by Jagrati, including those made on its behalf by Tirupati Vancom, that is me. No further claim or liability can arise or be maintained against us in this regard, and then you may take whatever steps you want to take against Jagrati. And kindly see the order at page 347. So he washes his hands of the matter. He says, you have paid me 6.57. I have deposited this money in court. Now you do what you want to do. So everyone gets scot-free.
Yes.
Now kindly see 347 is the order of the Supreme Court of 9th of May.
Yes.
Leave granted. So the appeal is admitted. SLP is admitted. Leave is granted. In view of the statement of the appellants, which is recorded in paragraph 1, 2, 3 of the apport, the appeal will remain confined to grant of interest on the refund amount. We are informed that the awarded amount, including interest, has been already deposited with the High Court. We permit the first respondent to withdraw the principal amount of 19 crores. The remaining amount shall be invested by the High Court in a fixed deposit with any national. So he receives my money, 657 from this, and that 4 crores which I have paid him, both of which on receiving from D1, he is obligated to pay back to me. So my cause of action to receive refund of monies arises in terms of clause 9 only when he receives the money. Any suit before that would be premature. A. B. As far as my challenge to the award goes, I was not party to the proceedings. It was entirely behind my back, not a shred of paper to show your lordship I had any knowledge. And secondly, that award attained finality is still not attained finality. It is still pending in challenge before the Supreme Court for whatever purpose it is. I'm not on the purpose, but the fact of the matter is award has not attained finality. It is still pending under challenge. The 37s were disposed of in March 2025. And a non-party to the arbitration who is not aware of the matter is said that you should have come to court early.
Yes.
Now kindly have, my lord, first what Dhanbad says, my lord. Kindly have the decision. 42F, your lordship has seen, my lord. Kindly see 42F once. There's nothing new which the Supreme Court has said with the greatest of respect.
Already settled.
Already settled. There's nothing new. They've just encapsulated it. This is what our court has also said. This is exactly what Gavril says. Put yourself in the shoes of the plaintiff and see if anything is contemplated. Kindly see 42F. The test for urgent interim relief is if on an examination of the nature and the subject matter of the suit and the cause of action. So the nature of the suit is suit for damages and return of monies. Subject matter is the two agreements and the award which is still pending. Cause of action is refund of monies after 9th of May. Before that, there is no refund of money. Subject matter of the suit is also the fraud which has been perpetrated by the respondents upon me. The prayer for urgent interim relief by the plaintiff could be said to be contemplatable when the matter is seen from the standpoint of the plaintiff. Now, my lord, kindly see. I have paid 11 crores. Admittedly, there is no dispute. D1 has received 6.57. Apart from cash, I'm leaving aside the cash component for now. In check, 6.57 crores to D1, 4.0 crores to D2. Admittedly, 11 crores I'm entitled to receive. Am I not entitled to security for this amount, my lord? I ask myself. Okay. Then, my lord, kindly see H. Even if the urgent interim relief comes to be denied, the suit of the plaintiff may be proceeded with without compliance with 12A if the test for urgent interim relief is satisfied, notwithstanding the outcome.
Not necessary. Injunction should be granted.
Grateful.
That is already.
That is on the merits of GA1, your lordship.
That is also our court has.
That is what our court has also said. Now, my lord, may I trouble your lordship with the judgment of this court, my lord? Mahesh Thakur versus Om Prakash Bhatia. Here, your lordship has considered. Kindly come to paragraph 29. Taking into consideration, I'm sorry, my lord. At page 12.
Yes.
Taking into consideration of the plaint as a whole. So your lordship goes to the plaint as a whole. This court finds that the plaintiff has elaborately explained the cause of action to file the present suit, and thus it cannot be said that the plaint does not disclose a cause of action. Then kindly come to paragraph 33. Your lordship notices 12A. Then 34 in paragraph 25 of the plaint. The plaintiff has made an averment for dispensation of leave under 12A. Under the facts and circumstances, it is most humbly submitted. My lord, I have said in more specific detail what is the urgency. He is going to withdraw the money. I am entitled to the money. In fact, 2 prayers of my plaint will become infructuous if I don't get interim relief. And the plaintiff to obtain dispensation has made following averments. Then kindly see 36. This is the only averment which was made in the application which your lordship has noticed. Then kindly see 37. In the said averment, in the said paragraph, the defendant numbers 3, 4 and 5 have not made any averment statement that the plaintiff after withdrawal of the previous suit has waited for considerable time within which the remedy of mediation could have been exhausted. In the case of so-and-so 2011-12 SCC, the Honorable Supreme Court held, and this is where I say, my lord, all averment arguments made beyond the petition are not to be considered. This is what your lordship has held. Pleadings and particulars are necessary to enable the court to decide the rights of the parties in the trial. Therefore, the pleadings are more of help to the court in narrowing the controversy involved and to inform the parties concerned to the question in issue, so that the parties may appropriate second legal principles. And then this is very well settled. Kindly see 38. Considering the above, this court finds that D3, 4 and 5 have not raised the said issue in their application, but only argued verbally and have filed written notes by raising the said issue. Thus, this court is of the view that the said issue cannot be decided as the same is not raised in the pleading and the plaintiff did not get an opportunity to deal with the said contention of the defendants. This entire argument which is advanced that you paid money in 2012, why were you sleeping for 13 years? This is nowhere mentioned in his application. It does not lie in the mouth of the applicant now to make these allegations. I could have dealt with them in my opposition. Then as per the contention of the defendants, cause of action arose on so-and-so, but the suit has been filed on so-and-so after the period of 10 months. My cause of action is 3 days.
Yes.
Thus, there is no circumstances which necessitated any urgent relief. The plaintiff had initially filed a suit before the non-commercial division, realized that the suit filed is commercial, plaintiff has withdrawn the suit. In paragraph 18 of the suit, the plaintiff has made out a case that on the first week of February, the plaintiff was informed with unwarranted harassment from unknown and unidentified men with the sole motive to dispossess the plaintiff from the suit property. It is also stated that such action took place on various occasions. Thereafter, the plaintiff received constant threat of being forcibly evicted. In paragraph 20, the plaintiff stated by the delaying the execution of deed of conveyance, D8 is proceeding with completion of the formalities, etc. So that was the facts of this case. My case is much more specific, my lord, with dates. Then Yamini Manohar is noticed. Then the next, our court's decision in Gavril is noticed. Our court's decision in Srishti is noticed, both division bench. Then 44, my lord.
Recent of Asa.
Asa, kindly see paragraph 11. I'll place the other two also, my lord, since protracted arguments have been advanced by that. Kindly see Asa, my lord, paragraph 11. What is contemplation? Contemplation thus would not mean an instant immediacy. Contemplation thus would not mean an instant immediacy, but the prejudice and the irreparable loss and injury that the plaintiff is likely to suffer if the plaintiff is made to wait for pre-litigation mediation. The court has to examine whether the facts and circumstances justify genuine apprehension as opposed to a camouflage of an irreparable injury the plaintiff is likely to suffer. The monies are withdrawn from the court and D1 says, I've already paid you by depositing monies in court. The plaintiff has filed the present suit before this court with a prayer for urgent interim relief. The plaintiff has filed the suit for specific grounds. Though the cause of action as mentioned in the plaint arose since the month of December 2014 till October 23, kindly see, my lord, the long period of cause of action, when the plaintiff has lastly issued notice to the defendants for execution of the conveyance deed. So that case, my lord, there was a cause of action arising for 10 years. Subsequently, the plaintiff has filed the suit before the regular division, and then the suit is commercial. He has withdrawn the suit in 24 and he has filed on 5th of March. And the plaintiff has made out a case that in the month of February, some unknown and unidentified persons have tried to dispossess, and then the case of urgent interim relief is concerned.
Yes.
So the application for revocation was dismissed.
Yes.
Now, your lordship knows, my lord, Gavril and Sarga, and your lordship has referred to them also. Kindly, my lord, permit me to cite them just for 2 minutes, my lord. 2023 SEC Online 2443. Kindly see paragraph 5, my lord, of Gavril. Suit was for the price of goods sold and delivered. My suit is for recovery of money. Your lordship knows Rahul S. Shah. Now, it is an inherent under 151 your lordship will grant, and especially here, my lord, this is my money. Kindly bear in mind, 657 I have admitted my money, I want it back, he takes it away. What can be more urgent than this? Then Malik, kindly see paragraph 9. No interim application was moved for 2 years and therefore leave to revoke 12A was filed. The legislature, kindly see 11. The legislature does not say that the relief should be urgently sought from the courts or the time period within which the relief is to be sought or the nature of relief to be sought to qualify as an urgent relief. The legislature only mentions that the suit should contemplate urgent interim.
Yeah, that's why I'm telling. We have to see the plaint, what relief you ask for.
Correct.
The urgent.
Great.
That's the cause of action.
That is the only cause of action which has to be seen. And then we'll kindly see just one thing, Malad. Kindly see paragraph 13 and 14. Why this distinction is made. The section stipulates 3 months time from the date of the application of the plaintiff, which can be further increased by 2 months with the consent of the parties for completion of the mediation. Take the example of a suit for recovery of money. Kindly see, Malad. Take the example of a suit for recovery of money lent and advanced. the defendant has huge debts in the market. Several claims of creditors against him are pending. When the plaintiff is contemplating filing of the suit against me, he is in the process of transferring his immovable property so as to defeat the claim of the defendant as well as other creditors. Immediately with the filing of the suit, the plaintiff needs to move an interim application and obtain an order restraining the defendant from transferring the property and to have the property taken possession of by a receiver to be appointed by this court. Now, if the plaintiff is to undergo mediation compulsorily, the defendant might keep it pending for 3 months. For 3 months, the plaintiff would be unable to institute the suit and hence unable to obtain any relief. In the meantime, the defendant could be successful in transferring the property, thus defeating the claim of the plaintiff. Hence, the justification for the exception in 12A that in suits contemplating urgent relief, pre-litigation mediation should not be required, could not be required. Now, my lord, after I file the suit, he withdraws the money. And then he says we should have done mediation. This is the intention of the defendant. He takes away my money.
Yes.
The legislature has used the expression contemplated to express the intention that any interim relief may be required at the time of filing of the suit or may be required any time the defendant expresses an intention to do some act to defeat the decree to be passed. So the test, in my opinion, is not whether an urgent interim relief is immediately required, but whether the averments in the plaint point to situation where even before expiry of 3 months, the plaintiff may have the need to obtain interim relief. And kindly see 21. On a reading of the plaint, particularly those 2 paragraphs inserted above, there is no doubt that the case for obtaining interim relief is indeed very weak. There is no description in the above paragraph of any act or deed on the part of the defendant necessitating any urgent relief. Nevertheless, it was possible for the defendant to deal with, dispose of its properties within the period of 3 months so as to defeat the claim of the plaintiff. So even if there's a weak case made out, in my view, the expression an urgent relief is contemplated signifies the inbuilt case in the plaint from where it could be inferred that in all likelihood an interim relief may be required in the period of 3 months when mediation carries out. More importantly, appreciating the case of the plaintiff in the plaint, a learned single judge of this court exercising interlocutory granted relief, and then it all this. I'm not troubling your lordship with the rest of it. So I filed the application instantly. Within 3 days of accrual of my cause of action, press D and E of my suit would be frustrated if, my lord, the monies are allowed to be withdrawn in the meantime. Because in my application GA1, I make out a case that this is a defaulting creditor. He has huge debts in the market. If he's allowed to withdraw this money, I will never get it back.
Thank you.
Yes.
If not, kindly comes to page 28
of
the petition.
Your application?
Yes, sorry, Malad, GA1.
GA1.
Yes. Because Malad, we still don't have a copy of the plaint. We assume Malad, whatever is there in the petition Malad, is also there in the plaint.
Page?
Malad, page 28.
Yes.
And you see Malad, the first relief in the plaint.
Correct.
That should be Malad with great respect to my learned friend.
Yes.
If this is his first relief, where is all these arguments saying that only when the money comes, then I'll have a cause of action?
Yes.
And he's aware of this. He's aware of this Malad from the previous suit in July, in September, our own showing.
Yes.
And all his reliefs are based on that. First relief is declaration award dated 29 June 23 made in the arbitral funds. They were not binding. And this is I had shown is directly contrary to the other suit which was filed, where the other who are the award debtors say award is binding on them.
Okay.
So on this basis, and then my lord, and my lord's judgment, my lord, kindly look at. I don't know, my lord, great respect, my lord, kindly look at paragraph 29. My lord's held, my lord, this is my lord's judgment which my lord he gave. Mahesh Thakur, my lord.
That is there.
Yes. My lord, paragraph 29. I'm not relying on paragraph 29.
Yes.
Taking into complaint as a whole, This court finds that the plaintiff has elaborately explained the cause of action to file the present, thus it cannot be said plaintiff does not disclose the cause of action. Next contention raised by the defendant numbers 3 and 4. Present application earlier should be withdrawn. Paragraph. Then, my lord, 33, section 12A, then 34. In paragraph 25, plaint has made an averment for dispensation leave under section 12A. Then, my lord, has set out, my lord, paragraph 35. Lordship has considered 40, 41.
Yes, I have taken consideration.
Yes, I don't know how much this helps him. Because Malad has to look at the plaint.
That's why I said with regard to consideration of the revocation of the leave, the total plaint is to be looked at.
Correct. And that's all I've said. It's a consideration.
I also told him, then I call for the plaint. Let the court ascertain what is there.
Malad, because I don't know, Malad, I'm sure plaint there's nothing extra, Malad, than the petition. Because we have, Malad, relied on the petition. And Malad will kindly look at it. Malad, whether Malad, because prayer A, Malad, gives him away.
Okay.
And Malad, I'm told, Malad, this I'm so sorry, Malad, Malad, I'm told, Malad, this summons has to be lodged, Malad, within 1 month. That's Malad, section 27. May, June, July, Malad, we are end of July. So no effort, Malad, also, Malad, to lodge, Malad, the summons.
That's why this is the right time. The original rule is to be amended. Now taking into consideration the commercial code.
Correct.
Writ of summons, the office should complete the scrutiny at the earliest.
Yes.
I find in 2 cases 420 days for only for scrutiny.
Correct. What's the point of having a commercial Malad, transit Malad scrutiny? And Malad, just Malad, which I heard Malad before Malad, I left Malad on the question of Malad having mediation. Malad, the admitted position in this suit, there was no pre-mediation which is required under section.
Yes, no, that is to be.
Yes.
It is not the case of Mr. Thakkar. That is to be taken.
Malad, whether I
as a
go or not
mediation.
go, Malad, that's not the point.
It
Malad,
is not. He
because
has argued that it is to be taken as a mediation,
Correct.
but he has submitted that the court has sent to the mediation. It was failed.
Lord, insofar as Lord, the GA1 is concerned, we have a lot to say. But Lord, since your lordships are only considering.
Yes,
12
GA2 has to be. GA3 has to be. GA3, Malad.
GA3. Hearing in connection with GA3 of 20, GA-Com 3 of 2025 is concluded. CAB.
I'm grateful.
है 12 बजे उससे पहले 3 मिनट है 2-3 मिनट
May it please your lordship, only thing. Not I thought I had concluded yesterday, but 2-3 points may I just indicate very shortly. Not on my application. And now we could understand yesterday why they requested the matter not to be kept yesterday and today, and it was kept today. They have filed an application in the meantime under section 8. They could have told us that we are intending to file. Please keep it on. Anyways, Milord, one thing, Milord, your lordship would kindly have a look at page 46. 3 pages I shall trouble your lordship with. Page 46. This agreement.
Yes.
The purpose of the loan is, in fact, I can show your lordship from the main agreement also. Milord, where is that page? The main agreement, wala? But page 46, your lordship would kindly take it. And he sees the towards the last of that end of that table, your lordship would find purpose of loan.
Page 46.
Page 46.
Of GA1.
GA1. But there are 2 page numbers.
Yes,
one is at the top right.
Purpose of loan.
Yes.
Facility
The facility will be utilized to purchase stock from Vedanta. Kindly marks this. This would have extreme significance, will it? That page. Annex 1.
Yes.
No, Annex 1. And also, my lord, kindly takes a look at page 81. This is the final agreement, my lord. Serial number 3. Details of principal borrower,
That
only
already-
Vedanta.
that we
And also the purpose. I mean, I misplacing this. Serial number 10.
facilities will utilize Vedanta.
To purchase the stock from Vedanta Limited. Now, their case is, my lord, kindly takes a look at page 238, second volume. They are saying some other bills are due. That has nothing to do with Vedanta. Kindly comes to page 237 at 238.
237.
At 238, my lord. My lord will find these are the bills of Gupta Power Technologies, which it's annexed to their affidavit in reply to the section 9. My lord, Gupta Power Technologies are the bills which are outstanding, nothing to do with Vedanta. And page 246 is
No, 237. What you
237 is an email, but kindly sees the bills which are outstanding.
Gupta Power Technologies.
238 to 245 Gupta Power Technologies are the bills which are outstanding. It's a bill discounting loan.
Yes.
Even if it is taken that I had agreed to a loan for bill discounting, which is that agreement, even then, that is only restricted to Vedanta. Bills of Vedanta, which has been squared off. But these are the outstanding bills, and I shall show from their pleadings also. These are the outstanding bills, my lord, page 238 to
No,
240.
this Gupta Power Technology
Some other entity dealing with the main borrower.
Okay. It is a Gupta, no? Okay.
Other entity dealing with the main borrower. I am not concerned with that. Page 246 is Gladius Microservice, another entity.
Yes. Next.
But in affidavit in reply, to which these are the annexures, no, in the same volume, affidavit in reply to the section 9 application, my lord kindly takes a look at paragraph, my lord, 4 and 5, because your lordship has seen at page 213. I'm sorry, my lord. It starts from, my lord, page 210. 209 is the covering letter. 210, the affidavit starts, my lord. At page 213, I shall be placing reliance on, my lord, paragraphs 4 and 5. Your lordship would recollect, my lord, the case which they had run in the section 9 court is that this was restructured. They had sought to run that case. And after restructuring, this is outstanding. Kindly see paragraph 4.
Was restructured by the petitioner. Reflected from this. Yes.
So restructured on such as, then I say that thereafter, in view of paragraph 5,
yes,
thereafter, in view of such restructuring, and the email dated such and such, the respondent was able to enjoy further assistance by way of entries dated such and such, and 10th April reflecting fresh chances in terms of restructuring. The particulars of the same are set out here under. Kindly see the invoice numbers.
Yes.
All Gupta Power, GPTL.
Gupta Power Technology.
Gupta Power Technologies Limited.
Yes.
And BEAPL, which is at page 246, minute.
Yes.
Some other minute. Gladiolus, some other. So, my lord, it is my humble submission that it may be restructured. They may have given a loan. They can haul up the defendant number 3, no problem. But so far as my client are concerned, it cannot be done. The other legal point, which I had missed out on arguing, is kindly takes a look at page 112 of the first volume. This is, my lord, the Reserve Bank of India circular. Now, the circular, my lord, starts from page 87. These are the KYC directions. It starts from page 87.
Yes.
My lord will kindly turn to page 112 where the relevant portion is, my lord. Kindly sees regulation number 1717.
Yes.
Kindly sees that this concerns, may I place it, accounts opened using Aadhaar OTP based eKYC, which is our case, is in non-face-to-face mode, our case, are subject to the following conditions. 1, there must be a specific consent from the customer for authentication through OTP. Nothing there. Kindly turns to page 113. My lord, clause Roman 8. Roman 6 first. Accounts, both deposit and borrowal, opened using OTP-based eKYC shall not be allowed for more than 1 year unless identification as paragraph 16 or as per paragraph 18 is carried out. If other details are used under paragraph 18, the process shall be followed in its entirety, including fresh Aadhaar OTP authentication. Then 8, a declaration shall be obtained from the customer to the effect that no other account has been opened. So the restructuring other loan accounts not possible, has been opened, nor will be opened using OTP-based KYC non-face-to-face mode with any other RE. RE is regulated entity. I shall show the definition that Ugro Capital falls within a regulated entity. Further, while uploading KYC information to KYCR, regulated entities shall clearly indicate that such accounts are open using OTP-based eKYC, and other REs shall not open accounts based on KYC information of accounts opened with OTP-based eKYC procedure in non-face-to-face transaction. Now kindly see the definition of RE, page 98. My lord will find non-banking financial corporations are included. Page 98, Roman 14, my lord, is regulated entities. My lord, C, 14C, all NBFCs.
Yes.
So, my lord, whichever way your lordship looks at this, my lord, the plaintiffs cannot be hauled up for this loan. And anyways, your lordship knows, my lord, I need not cite any judgment for that, that a director cannot be personally liable if he is a signatory to the agreement. We are not directors also. We are only a minuscule shareholder.
Thank you.
Those are my suggestions.
Fix it. Yeah, fix matter. Come tomorrow. Come tomorrow.
Hopefully, if I come tomorrow, my learned junior friend once said that I have a right to file a 518. I have filed it by coming tomorrow.
Day after tomorrow. Come day after tomorrow.
Day after tomorrow. I hope he doesn't take that point again. That's my statutory right.
Not only thing, day after tomorrow, I would not be there from the second half. If it's there in the first half, right?
In the list, let us counsel for the plaintiff has concluded his argument in connection with JCOM 1 of 2025, but due to paucity of time and counsel for the defendant could not start his argument. According to his adjourned, let the matter appear 1st of August.
Great.
Next.
But I'd started my submissions on the last day. And to try and keep it short, what I'll do is not give your lordship a rejog 5 minutes and then I'll try and keep it as short as possible. Now, not the dispute before your lordship, to remind yourself, remind your lordship, there are 2 suits before your lordship. One filed by Mr. Mukherjee's client and one filed by our clients. Now, the crux of the matter, really speaking, is this. The plaintiff's allegation in the suit filed by Mr. Mukherjee is that the holding of certain meetings of the trust by us are wrongful. Now, these are the earlier meetings. Our case is the holding of the later meetings by them is wrongful. Now, if our earlier sets of meeting are upheld, that's the end of the matter, because he did not give notice to our people at all. So his meeting would automatically go and your lordship would have the answer in both suits. So, to try and give it some form of equations or some math, it's like this, if your lordship ultimately holds that my meeting was valid, that should be the end of the matter. Now, why do they challenge our meeting? What are the grounds? Now, the 2 principal grounds of challenge, according to them, the principal ground of challenge was that Harshvardhan Lodha had ceased to be a trustee or had been removed as a trustee by virtue of orders passed by the High Court. Therefore, he could not have held these meetings or attended. That's the long and short of it. Now, they did not want to move the application, so we moved ours. Although
Right? Now, when we moved it, having heard us not submissions, they were inspired to make another submission. So it's not bad only because of Harshvardhan Lodha, may I refer to him as HVL. But it is also bad because Mr. Matilal, who was also at the meeting, had ceased to be a trustee by reason of not having attended meetings. So on the last day, I showed your lordship, their own case in the plaint is that he was a trustee on the date it was filed. So that puts an end to this. But the reason they had to make the submission was because they realized that knocking out HVL is more difficult. So they tried to take this, but I've showed your lordship the pleadings. I don't think I need to make any further submissions on that. So now it is going back to only this one issue for the time being. Could HVL have attended this meeting or not? That gets rid of the whole dispute. Now, for that matter, for that purpose, there are 6 dates. If your lordship would either note it or I can give your lordship a list of dates on it, but not the dates are this. One is Justice Munshi's order, which according to them resulted in disqualification of HVL. That is on the 18th of September 2020. So this is the first important date. Now, on the last date, I had started showing your lordship this order before we ran out of time. The summary of the order, I'll show your lordship the conclusions later. Now, really speaking, what that judgment seems to say is that, and it says so in no uncertain terms, in over a dozen places, that no order can be passed against third parties. Now, in the ordering portion where the reliefs are, again, he did not pass any order against the societies and trusts. So our stand would be, look, there was no order as far as the trusts are concerned. Now, there was one para in that judgment which gave the APL the right to dictate the manner of voting. In other words, how the voting will be exercised. So, this is what created the confusion. It is not there in the operative portion. He has said no orders can be passed against us. Now, whether this was an order against us or not may not matter, because I tell your lordship, it is very clear from the order, and Mr. Mukherjee seems to have made that submission also, that the orders were not directed against the societies or trusts. This seems to have been his submission. I'll be corrected if I'm wrong. So if that be so, Justice Munshi's order did not result in any disqualification as far as the societies and trusts are concerned. We are one of such. Please also bear in mind they were not parties to the proceeding. Now, against that, an appeal was preferred. And at the ad interim stage, a clarification is given by a division bench comprising of Justice Radhakrishnan. Now, that order is dated 1st of October 2020. Now, there, I'll show your lordship. I'm just giving your lordship the summary of my argument. There, your lordship will find that there is a clarification. It says that the disqualification, if any, on Harshvardhan Lodha is to be based on shares. So, if they are shares held by the estate of PDB in her name, then there is a disqualification which kicks in, but not otherwise. Now, to which now this clarification, there were 2 arguments which I had made when I had not argued. One is a clarification dates back. The second is, in any case, a trust or society doesn't have shareholding. So this disqualification based on shareholding only did not apply to trusts and societies, which also seems to be not the argument made by Mr. Mukherjee, because he says the appeal court had no jurisdiction because the societies were not there. So, if I am correct, even without getting into any more complex issue, the fact of the matter is there was no disqualification by virtue of these 2 orders. Now, the important thing is, even though we have a legal argument, it dates back, even more important is the fact that between the date of Justice Munshi's order and the division bench order at the ad interim stage, there is no resolution either of removal or cessation. No one took that stand till then. So it's clear that he continued. There can't be any dispute about that. Nor did the APL ask for his removal. Now, after this order, come 2 more dates. So, my lord, the APL writes 2 letters. And this is very important. The dates of those letters are, my lord, 12th November 2020 and 27th February 2021.
12th number 2020 and
27th February 2021. So they wrote to all, my lord, companies, societies, trusts, hospitals, they wrote to the whole world, saying that he has ceased to be a trustee by virtue of the 2 High Court orders. This is happening, Lord, after Justice Radhakrishnan's order. So, Lord, this is clearly, very, very clearly a overreach of the order. It is a misrepresentation of the order.
Yes.
And, Lord, if the order itself did not result in removal, then the letter by no stretch of imagination could have, without there being a independent resolution of removal. Now, Lord, despite my challenge at the beginning, my learned friends have not been able to, Lord, argue or Lord, show your lordship that there is a resolution of removal. They keep saying cessation on the basis of High Court order, which my learned friend says is an independent resolution. He'll do nothing. Lord, if the orders have not removed him, Lord, let us say it's an independent resolution for a time being. If there is no removal by virtue of the orders, then, Lord, whether it's an independent removal or not, if there is no removal by the High Court order, then, Lord, merely recording it will not result in his removal.
Okay.
And there is no resolution removing him. Lord, I challenge my learned friends to show.
Okay.
Now, these 2 letters which your lordship, Lord, I've given your lordship the dates, 12th November 2020 and 27th February 21. Lord, these have not surfaced. Not surfaced.
Okay.
They have not disclosed it.
Okay.
We find reference to it in the resolution, which I will take your lordship to. Now, so, my lord, this is the position. So, thereafter, my lord, comes the resolution recording the cessation, which is 16th of April 2021.
Yes.
So, my lord, following this chronology, according to me, there is no removal by court order. There is no removal by a resolution till now. 16th of April is the order, is the, my lord, meeting. Meeting, my lord, says that he has ceased to be a trustee on the basis of the High Court order. 2 High Court orders. Now, none of them say he stands removed. None of them. On the contrary, Lord, Justice Radhakrishnan's order removes the, my lord, purported disqualification, if any.
Yes.
So, my lord, this is overreach of the highest kind.
Yes.
Now, please bear in mind, Lord, these 2 letters are written by 2/3 of the APL committee, not 3/3. Out of the 2/3, one is a Birla nominee. So, my lord, the Birlas, my lord, have deliberately, my lord, pushed a resolution on the basis of a letter knowing it to be incorrect. And I'll make my submissions on that. I'll make further submissions on that. Because this is a serious matter which needs to be gone into. And this argument in my respectful submission has not been met.
Yes.
So, my lord, this was the situation. Now, if I am, my lord, correct in my argument, Lord, if this premise is correct, then, Lord, the 2 meetings which we held on 10th and 11th of February 2024, Lord, his attendance or non-attendance will not result in vitiating the meetings. So, my lord, in which case, my lord, our meetings, if held to be valid, other than, Lord, other grounds, one is, my lord, that he ceased to be, what's his name? Mr. Matilal ceased to be a trustee. I've showed your lordship that's wrong. So, my lord, other than that, Lord, there's third argument made. I'll deal with that in detail again. Third argument made is one of the trustees was, my lord, detained by the police. So they say, look, notice to him is no notice, even if sent to him by email. Now, the judgments don't show that. Reliance is placed on the jail code. Now, my lord, to that, my lord, 2 counter arguments I just give your lordship. The law I'll deal with later. Lord, let us say there's a company. Firstly, my lord, principles of company law will not apply here. But assuming there's a company or a trust, and, my lord, there are 5 trustees. One of them is, my lord, accused of breach of trust or stealing company property. He is arrested by the police after investigation of 1 year, 1.5 years, and put in. Now, does it mean that till, my lord, he comes out, no meeting of the trust can ever be held? Cannot mean that.
Okay.
It does not make any sense. the fact that someone is arrested and my lord remains in jail cannot result in my lord vitiating the holding of the meeting. My learned friend may have a different point on majority, not majority. That's a different thing.
Yes.
Now, Lord, your lordship will also bear in mind, and I'll show your lordship from the plaint, that they admit that the other trustee, Mr. Daga, Damani was in jail, no? Not Mr. Because lapse of time, I'm mixing up the name. Mr. Damani had been arrested. The other nominee, Mr. Daga, had admittedly received the notice. Admitted. Now, he could have protested. He could have said, look, that notice is bad because he's in jail. Now, please also not look at this dangerous argument made. Not 10 days later, when he is still in jail, they hold their own meeting. How did they give notice? Not what is sauce for the goose is sauce for the gander. Then their meeting must also be bad. It is very dangerous, not argument, not but desperation, not call for not desperate arguments perhaps. But this is treading on a razor's edge. Now, please also remember this. So, Lord, if notice to Lord Mr. Daga is admitted and he knows of the holding of the meeting, that I'll show your lordship, and the resolutions passed, could he then have gone and held not his meeting 10 days later without notice to the people appointed? Could not have. Because Lord Mr. Mukherjee's argument, please remember it, if there's an appointment made, it does not vanish without going to court and having it set aside. He knows there's a resolution passed, people have been appointed, didn't go to court and challenge that.
Okay.
So till then, he had to give notice. That's the argument he makes to attack my case. So, Lord, again, what is sauce for the goose is sauce for the gander.
So what would be effect if the person is in custody?
Lord, number one, Lord, my understanding, Lord, I could be wrong. Lord, we'll deal with his judgment because his judgments don't really deal with this point. He is relying on the jail code. What does it show? It shows that a person may not have access to electronic devices. Now, Lord, does that mean, Lord, if that is so, Lord, how could they have held their meeting? Number one. Number two, my learned friend is yet to show that this disability to obtain it, it's a personal disability. It's not anything else. It's a personal disability. Lord, let's say a person had fallen ill and he was in hospital. Could he have made the same argument? And he was unconscious. Let's look at it that way. Could he have made this argument? The meeting is vitiated. Maybe, maybe not. But not, it's stretching it. I'll deal with the law on that. I'll deal with the law on that. The fact is, my lord, if this notice has to be given, without which the meeting is vitiated, then his my lord, second set of meeting goes automatically. Because the conditions were exactly the same. He continued to be in jail for over 100 days.
Yes. Yes.
Now, Mlad, this would be Mlad, what happened. So, Mlad, therefore, after our two meetings, where Mlad, the composition is changed, they go ahead, hold the meeting. The date of that meeting is 22nd of February, 2024. No notice given to us, admitted. Neither to HVL.
Yes.
Not, and if I'm correct in my arguments, he was then entitled to notice in any case.
Yes.
Nor to any other continuing or newly appointed person.
Yes.
Nor to their own man.
Okay. Yes.
So, Mlad, this would be Mlad, my argument in brief. This is all I need to show your lordship. My meeting, not my removal, is non-existent. There is no resolution of removal. If that be so, the premise of his entire suit goes. And the other premise has been made up, not, I won't say from the bar, someone got inspired and has put 2 lines in the affidavit in reply. This is the situation. But the plaint case is clearly that Mr. Matilal is a trustee. He cannot go back from that. He cannot. It's more than an admission in the plaint. It's more than that. I'll make my legal submissions on that. So, Mlad, therefore, Mlad, again, to just stitch up this line of argument, HVL was and continued as a trustee. He held the meeting. He held it, not the meeting was held, he attended it rather, and notices were given to all concerned. One person, the objection raised is one person was in jail. You knew he was in jail. Therefore, what consequence follows, I'm not particularly sure. But if someone cannot attend for any reason, let us say one is traveling abroad and did not have access to his email, what happens? With knowledge of the meeting or otherwise. But it can't be said that the business of a company or trust will be completely paralyzed by one out of multiple members.
Okay.
Can't be. So, if this meeting is then valid, then the second set of meetings automatically collapse. This is the long and short of my argument. So, for this, let me first take your lordship to Justice Munshi's order and show your lordship. I showed it very briefly when I earlier started.
Yes.
Submissions were short, and if your lordship takes the relevant paras of Justice Munshi's orders, that starts at CS 21, GA 1.
CS 16, volume 4.
Okay, you want to give it from Order 7, Rule 11. Take it.
Order 7,
Please take my Order 7, Rule 11 in CS 16. Because your lordship has earlier marked that, so I won't show it from anywhere else. GA 4. It's at page 40. Sit down, give me the paras. Hold it. Now, I had earlier already showed your lordship that no order can be passed against the companies and no orders can be passed against third parties. He said there repeatedly, I'm not troubling your lordship.
Page 40.
Yes, it starts at page 40.
Yes.
But I'm not showing your lordship repetitive incidents of that, but some pages, if your lordship would come to, if your lordship comes to page 151. Page 151 first, volume 2. After this, ভুল ভাই জিনিস দেখাচ্ছি। That
yes.
But please come to page 151.
Yeah.
Which is internal page 112. Please take the third para. Now, what had happened, I'll just give you a lordship of background. What had happened over here was, just so that everything fits into place, there's a probate proceeding pending. Now, in the course of probate proceedings, they made an application. Their claim had been, look, all shares of all companies are owned by the estate, although PDB did not. Now, these companies, including publicly held companies and what are called tier 4 companies over which the state has no control, are going to be holding their AGMs. Please stop it. This was the long and short of it. So they filed several applications in which these companies' rights were affected and they got an ex parte order. Now, against that, these companies went up in appeal. That order I won't show your lordship. That order was set aside. It was said, look, you can't pass orders against third parties, and that too without notice. So give them notice and do it. Now, in their prayers, in those petitions, they had also wanted leave to serve the societies, trusts, and other things, which they never did. So only the companies against whom the injunctions were obtained, were served, they appeared. So, this is a hearing of those applications. Question is whether those injunctions could have been passed relating to the AGMs of these companies. This is the question before your lordship. Now, the prayer, I'm sorry, not to bother your lordship. Let me just show your lordship the prayer in those petitions. If your lordship takes inner page 8, which is at page 47. Page 47, inner page 8 of the judgment. So the prayers begin on the earlier page, and at page 8, your lordship will find prayer D. If necessary, notice be issued to concerned companies, trusts, and societies.
Page 48.
But page 47. It's not the prayers begin from page 46. But your lordship has GA 1735.
GA4.
No. This GA4, but on that page. On that page, not page 7.
Yes, page 7.
Yes, but if your lordship is at inner page 7,
yes.
On top your lordship find GA 1735 has been taken out, etc. Then the prayers are set out.
Yes.
Now, my lord, if your lordship turns the page, or rather, my lord, please see, Lord, prayer B. So that is relating to the AGM of Lord Vindhya Telelinks, Universal Cable, Birla Cable, and Birla Corporation.
Yes.
So they want orders over these. Then Lord prayer C is ask them to adjourn the AGM. And Lord, most important for the purpose of this matter, next page, prayer D. If necessary, notice be issued to the concerned companies, trusts, and societies of the MP Birla Group. So they serve notice not only on the companies, they did not serve on the society, serve anyone against whom they seek an order, because it says, look, without giving notice to the person against whom you are seeking an order, no order can be passed. I'll show your lordship that portion. Just pull it out.
Yes.
So now they did not give notice to the societies. Now, my lord, in this context, now, Lord, the background of this judgment. So these companies came and they said, look, there are many grounds on which you cannot pass any order against us. Number one, I'm not a party. Number two, the scope of probate proceedings is very, very limited. The only issue that can be decided is genuineness of the will and other such things. Anything else is beyond the jurisdiction, subject matter jurisdiction of not a probate court.
Yes.
Also, bars under the Companies Act. There were multiple arguments made. There was a galaxy of counsel appearing from Delhi, Bombay, all over the place. And because it was COVID, we had the privilege of hearing everyone on both sides. Now, in this context, please come to page 112. I'm sorry, it's internal page 112, which would be first page of volume 2. First page of volume 2.
Yes.
Page 151. Now, please go to the third para.
Yes.
There is no difficulty for this court to accept this proposition as submitted by Mr. Bandyopadhyay. Now, mark this. Probate court cannot extend its jurisdiction over a person or entity who is not a party to the proceeding. Now, this is there in a dozen places. Now, Lord, please remember, I am not a party, nor was I given notice, although he wanted to. He did not give notice. So, my lord, no order could have been passed. Now, my lord, from here, please come to. Yes, Lord, please also see the next para. Mr. Bandyopadhyay relied on, Lord, a judgment in the same matter. Krishna Kumar Birla reported in 2008 for SEC on the issue of his client having no caveatable interest, and therefore no order passed by the probate court can bind him. So, my lord, again, subject matter jurisdiction. According to the decision, jurisdiction of the probate court is limited, being confined only to consider the genuineness of the will. The proposition is a well settled. So, this is the finding. Is a well settled proposition of law. There cannot be two opinions about it.
Yes.
Just give me the next page. Commentary, Nadia. Then, my lord, if your lordship would take, Lord, 190 of your lordship's brief, which would be inner page 151.
Yes.
If your lordship not goes to the last sentence at the bottom, or I'm not 6 lines from the bottom, this view has been confirmed by both the division and single bench of this court, and view of the fact that the APL committee is well within the power to ask all entities which were under the control of PDB to exercise their voting right in regard to their investment in the share capital of any of the companies which are under the control of PDB, and in the manner considered by APL to be beneficial to the interest of the estate.
Yes.
So, my lord, having held no order can be passed, not he says this. All these entities of the group which have exercised their voting rights in accordance with the directions of PDB had to be alive. Now, Lord, this is the catch which they relied on. However, accordingly, now such entities would exercise voting rights flowing from their investment in the companies controlled by PD be in the manner to be guided by APL. Now, my lord, if I may just take your lordship back, my lord, that sentence. The view has been confirmed by both division and single bench, and in view thereof, APL committee is well within its powers to ask entities which were under the control of PDB, please mark this, to exercise their voting rights in regard to investment in the share capital. Now, a society does not have share capital. A trust does not have share capital. So even not according to me, having therefore said that no order can be passed in the third society, this is how the order must be read. Share capital means companies. So if at all he is passing orders only against the companies, and that will be clear from the operative portion of the order. Because my lord, just after saying this, my lord, please see. Oh, no order can be passed just after that. Just after. Now, my lord, after saying this, please come to page 154, inner page 154, which is 193 in your lordship's brief.
Yes.
Now, my lord, please go to the third para.
No order can be passed.
Therefore, so far as the three notice companies are concerned, upon consideration of submission made by Mr. So-and-so, 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 this court, on considering the ratio of so-and-so, cited by so-and-so, is of the firm view that for the present, the noticee companies not being parties in this proceeding, no order can be passed against them. So, my lord, having said, Lord, earlier that APL can pass certain directions, my lord, that is linked to shareholding. Now, but the next para says, look, no order can be passed against the company. So it's clear, my lord, there was a confusion. Now, my lord, to go back to this portion, my lord, which I have just showed your lordship, this confusing portion at page 151, bottom of 151, which I have just showed your lordship can make a noting this has been specifically thrown out by the division bench. Set aside. Your lordship can make a note, it's at para 132 perhaps of the division bench judgment. So, court said, look, having held that no order can be passed against third parties. 132. But the court says, not the division bench says that, look, having held that no order can be passed, how can you do this? So, this part also went. But one last point on this order, but I'm not getting further into any
This
further
order
detail.
remains. 193 page 154 order remains.
Blood.
In the
150.
division bench has
set
not.
aside, set aside.
No.
Set aside. Set
Division
aside.
bench has set aside this 154.
Yes, everything.
And this also 190
Yes,
also.
that's all gone. But it was not there after Justice Radhakrishnan's order in any case, but division bench has not set it aside. Now, my lord, please go to the operative portion of the order. So, but which will be page 473. Huh? Very DB, Nadur. Come on, guys. What? Lord, please come to 195. I'm sorry, my lord. 195, which will be inner page 156. I'm sorry, it will be 155. Page 155, which will be page 194 of your lordship's brief.
Yes.
Now, my lord, please see, my lord, the prayers which are being granted are set out. It says, suit in exercise of powers conferred under section 247 passes the following orders. And my lord, please see the orders. Plaintiff shall implement the decisions dated 19 July of the APL committee taken by majority, as also consequential decisions of the APL in furtherance of decisions, etc. So this is an order against Harshvardhan Lodha, not against me. Then not B. Plaintiffs are also restrained from interfering with decision of APL and any decision which might be taken by it in future by majority if the same directly or indirectly relates to the estate of deceased. And further, plaintiff number 1, now this portion, your lordship marks, is restrained from any holding any office in any of the entities of the MP Birla group during the pendency of the suit. So this was again not an order on me. Please also remember, there is no order of removal as trustee, but there's a personal disqualification which kicks in, which restrains him from holding any office of blood entities
in the wind.
Which must have been the ones which were present before the court, those 4 companies only, because he has held no order can be passed against third parties.
Correct.
So this order could not have been wide enough to cover these societies and trusts. not that it matters. This part was also not
Any
said.
of the entities.
But this clarification is given by Justice Thotatil Radhakrishnan, not just a few days thereafter. I'll point that out. So that's why I said, please mark this portion.
Okay.
But according to us, there is no order on any trust or society, number one, because he has said no order can be passed against third party. Number two, there is no order removing HVL. Please not make a note of these two. Then, the next prayer granted is defendants, which means the builders are restrained by injunction from interfering with APL decision by majority. So, these are the only orders passed. And the important thing is, my learned friend keeps making submissions that, well, some applications were filed by Mr. Lodha, etc., where reliefs were not granted. Now, Milord, those are also, Milord, perhaps taken care of. I tell your Lordship, why. Yes. Now, Milord, please see, Milord, the disposing part, 156. In view of the observations made herein before,
Yes.
the other applications are also disposed of in the following manner. Now, so, Lord, this is disposed of in the aforesaid manner. Now, we are concerned here with GA 834, which is item number 4. Now, see, what is the order passed here? In view of the discussion and observation made herein before, this applicant stands disposed of to the effect that this probate court cannot decide any issue against a stranger to the probate proceeding, and no order can be passed against this company.
Yes.
Now, Lord, please compare this with item numbers 1, 2, 3, which are disposed of, saying disposed of with no orders. This is disposed of with orders.
831, 832, 830.
So, Lord, the other applications are being disposed of, saying that they are either infructuous or no order is being passed. This order, Lord, is passed, saying that, Lord, very clearly, no order can be passed against a third party.
Observation made at page 108. Okay.
So, Lord, this is Justice Munshi's order, one chapter over. Now, Lord, the next chapter, appeal filed by the companies, saying, look, there is that one para which creates confusion, because, Lord, we are trusts and societies. We may not have been bothered for a very simple reason. Shareholding, there is no shareholding in us. So, we were not bound by these orders, or there was no order against us. There may not have been a confusion. But now, Milord, and also please bear this in mind, there is an affidavit of assets filed by both parties, referred to over here. The trusts and societies are not part of the affidavit of assets. That is, Milord, the finding.
Yes.
So, Milord, I could not have been part of PDB's estate.
Yes.
Now, Milord, what did Justice Radhakrishnan not say about this order? Please come back to prayer B, which is at page 155.
Yes.
Not the last sentence is Harshvardhan Lodha is restrained from holding any office in any of the entities of MP Birla during the pendency of the suit.
Correct.
Now, this part is not modified and changed by the division bench. For that, please come to page 199. 199 is where the order starts.
199?
Yes, Lord.
Of the DB order?
Lord, I'm sorry. Page on the number on the top right hand
yes,
side.
Yes, got it. Yes.
Now, Milord, if your Lordship would come straight to para 20 or at Milord, page 211.
Yes.
So, my learned friend, Milord, has showed the portions above. But the portion where the court passes the order, Milord, if your Lordship looks at it, Milord, that portion is gone. We may, however, clarify that the word implement during in para A of the 3 directions issued by the learned judge means abide by. Not ignore that. Not we are not concerned with that. The next portion. It is further clarified that the operation of para B, not that's the one I showed your Lordship.
Where from you reading?
Not page 200 and 12. That will be in a page
We
14.
clarify, yes.
Yes. We, however, clarify that the word implement occurring in para A among the 3 directions issued by the learned judge means abide by. We are not concerned with that. Next one. It is further clarified that the operation of para B among the directions would be a restriction on the plaintiff number 1 HVL. Now, let's see the next one. To the extent of it being a restriction from holding any office in any of the entities of the MP Birla Group during the pendency of the suit. Next few lines, not next few words. On the strength of the shares referable to the estate of PDB. So, change the complexion 20, not completely. Number 1. I have a second comment. I have showed the judgments that a clarification dates back to the date of the parent order. So, therefore, to explain this, if PDB had 500 shares in Birla Corp, voting for those 500 shares could not be used to appoint him as a director. His disqualification will come in by him exercising shares directly belonging to the estate, not otherwise. So, if he had his own shareholding or the public shareholders voted for him, that did not come in the way as far as companies are concerned. But we are not concerned with that. But I am on a simpler point. I am a society. There is no question of any shareholding in me. So, disqualification, if at all, related to companies, and that too based on shares directly held by the estate of PDB. So, complete clarification over here. First, by Justice Munshi, it doesn't operate against third parties. Justice Munshi also referred to shareholding. This makes it clear shareholding, but only directly held by PDB. So, this is the
entities of the MP Birla during the pendency of the suit on the instant of shares referable to the
correct. Shares referable to estate.
Yes.
Now, shares referable to the estate has been discussed, considered, and I'll show your lordship when I take your lordship into Justice Sivanyanam's judgment and Justice Bhattacharya's judgment. They clearly say referable to the estate only means only the shares held personally by her. So it can go at the most to tier 1 company or tier 2 company. It cannot be spread to tier 4 companies, which these were. And doesn't spread anywhere to trust, societies, anything.
Okay.
So, therefore, 2 conclusions from here, Number 1, if at all there was any disqualification with regard to the trust, which I say there is none in Justice Munshi's order, that too vanished, evaporated on this day. Now, I would have understood if they had taken a resolution between them to remove me on the basis of Justice Munshi's order. But that also they didn't do.
After
On the contrary, once this order is passed, now, the question before your lordship is, after seeing these 2 orders, could anyone have honestly said that he stands removed by virtue of Justice Munshi's order or by virtue of the division bench order? Could not have been done. First, let's get rid of this legally. Get rid of it. That we'll go into later.
Yes.
So, very, very clear here that there is no disqualification against HVL or against the trusts or societies on the basis of these 2 orders.
Correct.
Now, why I lay stress on this is, now, please come to the resolution which was passed by them. Now, your lordship has perhaps noted the date of this order. This is dated, 1st of October 2020. Now, please take the resolution which is at page. Your lordship would please take GA1 of CS 21. Page 43.
Yes.
Now, my lord, if your lordship comes to page 43. Forget it, okay. Now, my lord, see the first paragraph. The society is in receipt of various communications dated 12th November and 27th February. I have referred to this, my lord. I have given your lordship those dates from the office of APL of the estate of so-and-so. Copy is enclosed. Now, they have not enclosed these copies. Now, my lord, please go to Lord, the third para. Lord, their own case over here is Lord, middle of the para, so I don't trouble your lordship. They admit that Harshvardhan Lodha became a trustee and governing council member about halfway down. His son, Sri Harshvardhan Lodha, became trustee and governing council member of the society in September 2003. So he was there from 2003, admitted position.
Yes.
Then, Lord, they go on to say Sri Lodha passed away in 2008. After him, his son, who's an intestate successor of R.S. Lodha, is also one of the claimants to the estate of Srimati Priyambada Devi Bela, later became president of the society. So, now, Lord, these things are admitted. Now, my lord, please then go to the bottom of the page where, my lord, there are 4 orders set out before that. On 2nd November 2020, the society received a communication from whom? From Khaitan and Company advocates, enclosing the following decisions, judgments, copy attached. So, my lord, 19 July, so on and so forth. Then, my lord, your lordship will find item 3 and 4 are Justice Munshi's order
And the dividend
and
bill.
Justice Radhakrishnan's order. Now, my lord, please turn the page. The letter dated 12th November received by the society from APL committee, copy attached, not attached over here, not surfaced till today, contains judgment and order of 18th September of the learned single judge and the order dated 1st October of the Honorable Division Bench at Calcutta passed in the matter of probate proceedings in respect of late Srimati Priyambada Devi Birla. The letter dated 27th February received by the society from APL committee informed that the APL committee at its meeting on 26th February has decided by majority to nominate the following persons. So they are now nominating. Who's nominating? APL.
Correct.
As if he has the right to interfere in the trust. Now, Lord, please see thereafter. Lord, just after Lord, the 2 names, the APL committee in the above letter of 27th February has also stated that the existing trustees, governing council, members of the society do not include Sri Lodha anymore on account of the judgment of 18 September read with the order dated 1st October.
Yes.
And please see the language, do not include.
This is not correct.
Now, thereafter, Lord, they say they have obtained their opinion from a retired judge of the Supreme Court on 2 questions. And your lordship will see item 1, whether Mr. Lodha ceases to hold office of trustee and chairman of managing committee. So that's question 1. Now, my lord, after those 2 paras about the 2 questions, the opinion of Justice so-and-so in the above 2 queries is the affirmative. So, my lord, a learned judge has said a learned judge, my lord, not sitting in court, has given a judgment, which is now binding and being executed. Not, my lord, the order of Justice Munshi, not the order passed by Justice Radhakrishnan. What is being executed? A order or a opinion of a retired judge. Now, please, my lord, see, my lord, how this goes. Please go a little further. Forget it, forget it. Oh, very well. Now, please see that question also, my lord, as he points out. Question 1. Whether Mr. Harsh Lodha ceases to hold office of trustee and chairman of member of managing committee in these societies. Now, please see the next few words. Very important. Consequent to a conjoint reading of these 2 orders. Now, my lord, no one, not unless he was under the influence of something, would have said that the orders stand in his removal. Now, my lord, please see thereafter. Opinion of Justice so-and-so on the above 2 queries in the affirmative. A copy of the opinion is enclosed. Not enclosed here. Not there. Copy of memorandum is also enclosed. In view of the above, your consent is hereby sought on the following resolution, which are intended to be passed by circulation. So, my lord, your consent is sought on the following resolution. Now, but two things before your lordship reads the resolution. Your lordship has to see whether this is a resolution resulting in or asking for his removal and removing him. Now, my lord, please see. So, my lord, what is it that they want to pass? Resolve that. The cessation, not removal. Please mark this. The cessation of Sri Harsh Lodha as trustee and member of the governing council of the society, consequent. So, it is not happening independently, it is happening consequent to the judgment of so-and-so date and so-and-so date passed by the division bench in the matter of probate proceedings in respect of the estate of so-and-so as communicated by the office of APL. So, my lord, APL is communicating on the basis of that Khaitan company letter which I have read out to your lordship.
Yes.
Of the estate of so-and-so by their letter of 12th November and 27th February. Now, my lord, if they are implementing these two letters, please disclose it. Why shy away? Why have they shied away? And not so. Therefore, what is the resolution? So, cessation, now see the last few words. Be and is hereby noted, confirmed and taken on record. There is no removal by itself. It is noted, confirmed and taken on record. There is nothing saying we remove him. Now, not if these orders do not result in his removal, not then this resolution is nothing. It's zero. Because it is consequent to the orders.
So, as per your submission, they have taken this resolution interpreting the order passed by this
Correct.
court, and
Not-
the order passed by this court is something else.
Something else.
Which
Blood, I'm obliged. I'm obliged. Blood, if I may just put it not again in another manner, blood, they are proceeding on the basis that he has seized consequent to the orders of the court. And APL, which is authorized to do so, is saying, please take a resolution removing him because please see the language.
Removing, but they have not removed. They have not
Yes.
passed a removal,
Yes.
but they have taken a
Yes.
resolution of cessation.
They want him to record that he is no more there on account of the judgment. Not automatic. It has followed consequent to the orders. This is the order.
That's why they are interpreted.
Correct. So, my lord, if the order does not remove, then nothing, my lord, remains. Because there is no independent resolution of removing. So, my lord, he continued is my respectful submission.
Okay.
And your lordship has found the date, 16th of April, 2021. Now, my lord, I had made all these submissions. Lord, these have been met only in a particular way by saying this is a independent removal. Now, how this can be independent removal, I don't know. Not merely saying so can't be.
After this, there is no other further.
Nothing. Admittedly, there is no other resolution. None has been disclosed. Claim is only on the basis of this and nothing else.
Okay.
Lord, your lordship has heard my learned friends' arguments, two of them. There is no other ground that they have. They only say that this is a independent removal.
Yes.
By the trustees. Because not APL could not have removed without a independent. Not, at the most, they can tell them, please take steps to remove, and that's what.
Yes.
Their stand is automatic cessation by virtue of the
Orders.
court orders. That's all. So, my lord, this is what, my lord, happened. Lord, which I say could not. Lord, this sentence, these two sentences I've showed your lordship is a clear misrepresentation of both the orders. Both. Now, how this could have been binding on the society is nothing. Now, not thereafter, not the appeal is finally heard. And not the division bench gives its final order. So, my lord, I intend to finish off that part also today so that not leave me with. I know. No, we have to start that off. Please don't do that. Now,
yes.
But if your lordship takes, not goes back to not page 214 of GA4. But just after Justice Radhakrishnan's order ends, not it begins at page 214.
The final order of the DP.
Yes, yes, yes. Now,
Yes.
Lord, if your lordship would not, their submissions, I will not trouble your lordship with the submissions, not detailed submissions, but not the judgment really starts at page 220, not internal page 226, which would be para 103 at page 442, volume 3.
Yeah, volume 3.
So, Lord, it considers every aspect of the matter.
243. 443.
But 440, page 440.
Yes.
But your lordship can just make a noting. I don't intend to show your lordship. But para 103 is where the reasoning starts. Your lordship has para 103 there.
Yes.
So that's where the reasoning starts. Now, my lord, I won't trouble your lordship with the whole of it. Now, if your lordship would come 3 pages later, not to inner page 229, which would be not the inner page at the bottom, it would be page 442.
Yes, yes. No.
So, my lord, they discuss not whether the Succession Act is a complete code or not, and my lord, if your lordship sees from my lord para 105 in Kanwarjit Singh Dhillon versus Hardyal Singh Dhillon and others, the Supreme Court held that it's well settled law that the functions of a probate court are to see that the will executed by the testator was actually executed by him in a sound disposing state of mind without coercion or undue influence, and the same was duly attempted. It is therefore not, mark the word, competent for the probate court to determine whether the person had or had not authority to dispose of the suit properties which he purported to bequeath by the will. The probate court is also not competent to determine the question of title to the suit property, nor will it go into question whether suit property is bequeathed by the will or joint ancestral properties or acquired properties. Now, but what does the word competence not indicate? The court is talking about the jurisdiction of the probate court. When it lacks competence, it is indicating that it does not have the subject matter jurisdiction. And this is crucial to a matter because I've showed your lordship AR 69 Supreme Court, Sachindranath's case, official trustee. If it does not, then the order is void, a nullity, as if it did not exist and need not be set aside. So, this is what it says. Then, few lines after that, it refers to Ishwardev, and your lordship will find a sentence saying Succession Act is a self-contained code, etc. And then, bottom of the page, the probate court does not decide any question of title or of the existence of the property itself. Then, having noted all the judgments, your lordship will take these last 7 lines of the bottom of page 230. Whether the testatrix had title to the property or not. Your lordship has found the question.
Yes.
Basically, is a question to be decided by the civil court. Since after proceedings relating to adjudication of the civil dispute between 2 sets of adverse parties, further it was held that the grant of probate does not confer any right title upon any person in respect of any property, since all such questions are subject to adjudication in an appropriate civil court. Now, let's see the next line. In light of the above settled proposition, we cannot approve the findings rendered by the learned single judge, having ventured to go into the entitlement of the estate to control, to exercise control over tier 3 for companies.
Yes.
Then, please come to 106. This is the question, para 106. I'm very sorry, not para 106. Issue 1-2. Third-party injunctions can be granted in exceptional cases by the probate court for limited purpose of protecting the estate. However, the internal affairs, marks this note, of third-party companies cannot, under normal circumstances, be interdicted by probate court. Then, in relation to this, now, comes to 108. Para 108, which will be page 233 of page 446.
Yes.
Lord, decisions are cited. I won't not take that. Please look at the last 4 lines at the bottom of that page. We need not labor much on the issue, as the learned single judge has rightly noted the proposition of law in that regard and held that companies not being parties, they are not amenable to the jurisdiction of the probate court. So, Lord, that part is not affirmed.
Yes.
While considering whether the companies can be joined as party defendant, court held that notice companies can, mark this, neither be joined as a party defendant, nor can the order of restraint be passed against such companies who are not party to the proceedings. So, my lord, no party, nothing. Now, my lord, further, the court held it cannot extend its jurisdiction. So, my lord, court itself can't extend its jurisdiction to a person
Who is not a party to the
who is not a party to the present proceedings. Further, the probate court cannot extend its jurisdiction over a person or entity. So, my lord, that expression entity of the MP Birla Group covered, who is not a party to the proceedings. Further, it was held that since the noticee company being not a party to the proceedings, no order can be passed against it. Respondents have filed, now this is important, cross objections against these findings. So, my lord, the Birlas challenge this finding of Justice Munshi against these findings recorded by the learned single judge, which needs to be rejected. So, my lord, cross objection gone. So, they can no longer urge that the order is binding on any third party.
Yes. Yes.
I'm sorry. Then, my lord, in the decision of 2016 SCC Online, Calcutta, Honorable High Court observed that the court has no hesitation to hold that the probate court cannot pass any injunction against the third parties, as third parties who has no caveatable interest in the probate proceeding cannot be allowed to be added as a party in probate proceeding. And also for the reason that no order can be passed affecting the right of a stranger without adjudication of his right in the probate proceedings is impossible, as the probate court cannot decide any foreign issue unconnected with the probate proceeding. Let's see how far the division bench goes. Then, my lord, please come to para 109. Lord, issue number 2. To decide the extent of the estate of the deceased, the court has to ascertain the powers which could be exercised by the deceased testatrix herself. Not, if I may be permitted to pause for a second, but what it's saying really is, if the testator had the shares, court will have jurisdiction over that share only. In other words, affidavit of assets. This is what it goes on to say. So, not the powers of the probate court while appointing an APL are coextensive with the powers of the testator. So, my lord, you sit in the armchair of the testator. Now, that's an expression your lordship has heard often. As a necessary corollary, the powers of an APL formed by the probate court cannot exceed such limits. Now,
they cannot go beyond that.
Correct. Now, my lord, please, now, my lord, go back to the facts of our case. I am a trust. But trusteeships are not heritable. They are not heritable. That's well decided. Control is not heritable. Very naughty boy. He also says judgeship is not heritable. But if it was, well, maybe my father and me would also have been. But given this factor, if she had 500 shares, that is all that not HVL, or rather the estate can claim and the APL can claim. Then, my lord, please see para 110 with regard to the above shares in several companies. PDB's powers were restricted to her ownership of the particular shares in different company as mentioned in the affidavit of assets.
Correct.
In such context, the expression controlling interest should not be confused with personal influence of the testatrix. Whatever might have been the personal influence of the deceased, the same was intangible and restricted to herself. The charisma or personal influence of the deceased might have helped her in carrying out her will in the affairs of the companies, but do not comprise of tangible incidents of her property or estate. But look at this sentence. But I don't know how these arguments have been made. after this clarification. Now, not before I go to the rest of it, please remember, SLP filed, stay refused. Stay refused specifically. I'll show that order.
After this order, any AGM was conducted?
Not AGM of a trust. I've told your lordship, we held 2 meetings with their challenge, and they hold a meeting without notice to me. So that's what happened. Now, my lord, 111. Thus, it cannot be said that her personal influence is in any manner a part of the estate. Now, coming to the issue of controlling interest, it's been argued extensively that PDB had control over the affairs of the second, third, and even fourth tier companies by virtue of a shareholding in tier 1 companies. However, at the ground level, such influence is only theoretical as an incident of a actual shareholding in the tier 1 company. The mathematical advantage which PDB might have had by virtue of majority shareholding in tier 1 companies could only translate to assertion of influence in the tier 2 companies, because tier 1 company held majority in tier 2, so that's her own shareholding. On that basis, yes. In the tier 2, 3 companies of actual presence of PDB in the shareholders meeting and other exercise for PDB participated by virtue of a actual shareholding. Definitely, it was open to PDB as a majority shareholder in tier 1 companies to attend shareholders meeting and assert her influence by virtue of voting rights or otherwise as part of incidental rights of the shareholder. However, without actual participation in voting and other decision-making process, such advantage would be merely inchoate. Now, let's see the next paragraph. As a natural corollary, the APL to be appointed by the probate court for looking after and managing the estate of the deceased committee steps into the shoes of the deceased and does not have an iota of right or power more than the deceased would have had. Hence, at best, para 116, the probate court can direct the APL personally or through its appointments to register itself as agent as members of the companies in capacity of owner and shares actually owned by PDB in such companies. Upon such registration, APL nominees would function as shareholders and in such companies would have all incidental rights and controlling power of PDB, which she would have had by virtue of such shareholding, including voting rights, participating in rights in decision-making process and meeting. Now, please see the last line. However, the probate court cannot go an inch further than that in interfering with the business of the company. So, then, my lord, the next portion, which your lordship will then see, but please come to para 128, which would be at page 251, internal page 251. That will be in the next volume, I'm sorry. Now, I'm showing a lordship where that portion was specifically not dealt with. Now, please come to the bottom of this page, not inner page 251, which will be page 464.
Yes.
Not last 7 lines. Thus, in several cases, the Honorable Division Bench has emphasized the rights and privileges exercisable are incidental to ownership of shares and stocks, and therefore a different meaning cannot be given, nor decision can be understood to mean that DHO's ownership rights in shares and stocks, APL will be entitled to exercise rights, powers, and privileges. So it says can't. Then, my lord, from here, if your lordship then, my lord, comes to page 253, which will be a part of that same para. It's a long para, but if your lordship comes to 253, about halfway down the page, sentence beginning with thus a careful and cumulative reading of all the findings, observations, the correct interpretation would be that the controlling power is proprietary right of ownership of stocks and shares. Furthermore, the court also specifically held that APL has to apply to the company as required by law to record their names in the register of shareholders, register of members, and the company will have to consider such application in accordance with the articles and provisions of law which govern the same. Now, let's mark the next few lines. Therefore, no extraordinary power was granted to the APL that they were to abide by the dictates of the Companies Act. Therefore, it would be incorrect way of interpreting the judgment to pick up a few words and sentences to hold that the controlling block of shares would mean rights over the shares which were not standing in the name of deceased. So makes it clear, if not standing in a deceased, it's not there.
Yes.
And not in a trust, of course, there are no shares. Then please come to page 255, which would be page 468.
Yes.
Not bottom of the page, last two lines. That the court in a probate proceeding cannot pass any directions encroaching on the jurisdiction of the board of directors or taking over the manufacturing units by purchasing its shares. So, he couldn't have even passed directions against the company. And they knock off directors one by one. They say, appoint my nominees A, B, C as directors. And they do so. Lord, your Lordship has seen the other matters. All those proceedings arise out of this one interpretation of those two orders. Now, my Lord, further, the court categorically held that APL should be made to agree so that APL can exercise power of control over the management of BCL by, that's Birla Corporation, by following provisions prescribed under the Companies Act, and in case APL fails to discharge its duties, probate court can pass necessary directions on APL for taking steps in accordance with law. Further, the probate court at best can pass necessary directions upon APL to initiate appropriate proceedings before the appropriate forum for seeking appropriate rights on relief. And it is only that appropriate forum which can pass appropriate order after adjudicating rights. So go to a civil court. At the most, not APL, what it could have done, obtain leave from the probate court, go to the civil court, obtain the reliefs after taking leave of the civil court. So, yes. If not, your Lordship looks at this, what they have tried to get in that order, at that meeting is exactly what is not prevented over here.
But they have done their own.
My Lord?
But they have done their own.
They've done their own. On the basis of opinion, as if that is the order of court.
Yes.
But one humble prayer, if I may have, I came to court, I've got fever, but I just had a few medicines today. In case, your Lordship has kept it tomorrow, I think, at the same time. So, in case, the fever goes up, I'll not come, but I've come for this only. But I'm just giving your Lordship a little warning. There's a possibility I may not come tomorrow, in which case, please give a further time. But if I do come, then I'll do the matter.
Okay.
No. I can't. For him, I can't do this. If I have to, I won't come. If I come, I will do the
Counsel
matter.
for the defendant number 2 in CS 16 of 2024 and plaintiff in CS 21 of 2024 has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter come tomorrow at 12 noon. Thank you.
After the question, I'm pretty sure.
May I, with my lord's kindly mention, my lord, I sought leave, my lord, to file with short cause title. That was granted. My lord, application made, served on the official liquidator's office, filed on the 23rd yesterday. My lord, after 6 days, they return it saying that the back sheet does not have my registration number and email ID. My lord, the Vakalatnama, my registration number is there, my lord. Only on this ground they're refusing, my lord.
Put your number.
But if I am willing to do it, my lord, it has to be signed by the registrar. He will do it, oath commissioner. They say no, you have to file afresh. I mean, serve afresh.
Leave is granted. Leave is granted to add the phone number and
Enrollment number and email ID.
enrollment number and email ID in the back page through pen.
May I be permitted to mention a matter, my lord? I have mentioned this matter on last 2 weeks occasion, my lord. Lordship at both occasions has allowed the matter, but it has not appeared in the list. My lord, today I have been understand, my lord, from the clerk, my lord, who is doing the department has probably misplaced one of the, my lord, the CA. That's why it is not, my lord, unless it is come in the list, my lord, we have the copies, we can reconstruct if required, my lord, but it's not given in the list, my lord.
If it is not traceable, what can be done?
My lord, unless it is before your lordship will not be. I have copies, my lord. I can reconstruct if that is
which number?
Lord.
It's not there. काम करो नेक्स्ट डेट में ना देख लो मिलेगा तो ठीक है नहीं मिले तो नंबर लिख के फाइल नॉट रेसिबल करके दे दे इसमें ना फाइल नॉट रेसिबल करके दे
And my lord, one more matter for this is a new application. My lord, it is due to appear on 14th of July. It is not appearing.
Not appeared.
Lordship, may I be permitted to mention serial number 9 and 10 company petitions in respect to which I have 2 applications. May
Not listed.
No, Lordship, may those be listed for further orders, Lordship.
What order required further?
Lordship, this is with respect to the inclusion of the measurement of the property which the liquidator had taken possession of. Lordship, that is already in record, only the measurement needs to be incorporated. And there is, Lordship, may I be also for inclusion, 2 company matters, Lordship. May those be included in the list, Lordship.
For what?
Lordship, I am appearing for the state in the matter, Lordship. There are further orders to be passed in my application, Lordship. May it be included in the list.
May I be permitted to mention what company application for inclusion in the list, further?
Lordship mentioned one matter regarding fire and general insurance. Order passed on 25th June 2020. On the last line of the order, Lordship, modification of the order. Last line is the official liquidator is directed to pay rupees 3,000 per month as medical allowances to the company paid staff of rupees 3,000 instead of 2,000.
Okay.
Yes, Lordship.
Yeah, उसको mention कर दो for correction.
Lordship, may I be permitted to mention some Avani group matters which were left out. So may these matters be clubbed together.
Left out?
Yes, only
You
4
have not been issued not notice or you have not some.
No, these matters were already filed in 2019. So all the other matters are running in the list. Only these 4 matters were missed out. So let these matters be included in the other matters.
Yes, call the list.
I put the petition, my lord.
Yes.
Correction, my lord. Paragraph number 9 and 10.
What?
My lord, I am for the official liquidator. My lord, paragraph 9, my lord, line number 3. My lord, the execution deed will be executed in favor of Shobhan Rai. He is the ex-employee.
Namely, Shobhan Rai. Who is nominee?
Through his nominee, namely Murali, not that.
That is the prayer in the application. That was the prayer.
Because my lord, the Muralilal Agarwal's nominee is the my lord, the Shobhan Rai.
Application.
Application to din.
You are having the application.
No,
application to.
एक काम करो इसको ना.
My lord, yes, my lord, I am having this application. But this is the my lord, the summons. I'm sorry, my lord, if it is And this is the application affidavit.
No, summon only prayer. What is the prayer?
Yes.
Ex-employee, ex-worker by the respondent. So what you want?
Well, the owner is the Mr. Murarilal Agarwal. His nominee should be the Sohan Roy.
Who is the ex-worker?
Ex-worker, my lord, the Sohan Roy.
Then kindly see the prayer B. That's why. Direct the respondent needful executing the deed conveyance in favor of the ex-employee.
No, ex-employee, my lord, your lordship is correct. But he cannot be the nominee. He is the nominee of Murarilal Agarwal. My lord, he is the nominee of Murarilal Agarwal. Here
Who
it
is the
is
ex-employee?
Yes.
Ex-employee, who is the ex-employee?
Ex-employee is
Shobhan
my
Roy?
lord, the Shobhan Roy.
Now,
my lord, kindly see through his nominee. He cannot be the nominee. He is the nominee of Murarilal Agarwal. Murarilal Agarwal is the owner. He is the landlord. He will execute the deed in favor of my lord, the Shobhan Roy.
So nominee will not come.
Yes.
In favor of the Shobhan Roy.
Shobhan Roy. Yes.
That's all.
That's all. Or
His
my lord,
nominee, namely Murari, will not be.
yes, my lord, Shobhan Roy being the nominee, my lord, that would be appropriate.
Being
my
the
lord.
nominee.
Being the nominee of Mr. Murarilal Agarwal.
I handed over the minor. Correction portion, मैंने handed. Paragraph 9 and 10 minor.
The matter is mentioned by the learned advocate for the petitioner for correction in the order dated 11 June 2025. He submits that in paragraph 9, line number 3. Line number 3 is to be corrected. Who is the applicant?
Applicant is my lord Murarilal Agarwal.
क्या बोला? Is to be corrected. Is to be corrected. Corrected as
nominee of the applicant.
As nominee of the applicant. As nominee of the applicant instead of bracket में through its nominee, namely Murarilal Agarwal. Similarly, paragraph 10.
My lord, page 4, my lord, in favor of the nominee of the ex-workers. Ex-workers cannot be the nominee. In favor of the nominee of the Murarilal, my lord, the same thing.
Simultaneously, in paragraph 10,
The applicant,
page 4, first line shall be read as in favor of Shobhan Roy. No. In favor of the nominee of the applicant.
Yes, my lord, that would be the applicant.
No. Paragraph 10, page 4, first line, read as in favor of the applicant. In favor of the nominee of the applicant.
My lord.
Instead of nominee of the ex-worker.
Yes.
Ex-worker. ठीक है? In view of the above. In paragraph 9, line number 4, line number 3 and 4 shall be read as after the word Shobhan Roy. After the word Shobhan Roy shall be read as through its nominee, namely through. After the word Shobhan Roy, it shall be read as nominee of the applicant. As nominee of the applicant instead of through its nominee, namely Murarilal Agarwal. Simultaneously, in paragraph 10, page number 4, line number 1, after the word favor of shall be read as the ex-employee namely shown after favor of shall be read as favor of, after the word favor of shall be read as the nominee of the applicant instead of nominee of the ex-worker. This order may be incorporated.
It can be extended, my lord.
In this order may be incorporated with the order dated 11 June 2025. Full stop. Full stop. As the order is corrected today, thus execution of the deed is execution of conveyance deed. Date for execution of conveyance deed, registration of conveyance deed is extended for a further period of 4 weeks from date.
Yes.
Let this order be incorporated with the original order. I am deeply.
Next.
Lordship, in this matter, I am for the official liquidator. We have filed our
रिटर्न डेट नहीं है, पहले तो था, पहले का डेट नहीं है, 16 जुलाई. Yes.
In this matter, I am for the official liquidator. We have filed our requisition to the assistant registrar for issuance of summons. I do not know why today the matter is
No,
appearing.
date is not there. Returnable date is not there. The matter is listed as to be mentioned. Not to be mentioned. It is. हाँ कहाँ रखी है कंपनी में
जजेस साउंड्स की
आधा ऊपर आधा नीचे इसमें क्या करते हैं यार कौन बनाता लिस्ट आप लोग स्पेशली फिक्स मैटर ऊपर क्यों नहीं करता नहीं ओरिजिनल साइड कंपनी नीचे आएगा तो आप आपका बीच का ये नीचे बीच में क्यों कर दिया हाँ क्या बोला as to be mentioned by the office as the petitioner applicant / official liquidator has submitted requisites for service upon the accused persons. Full stop. The office submits that there is no returnable date is mentioned in the order dated 23rd July 2025. Accordingly, matter is placed before this. In view of the above, let the notice be issued, summons be issued upon the accused persons, returnable by आज कितना तारीख है by 13th August.
13th August.
Next.
I am for the respondent official. I am for the petitioner, Lordship. This is my application, Lordship. This is application by the petitioner creditor, Lordship, for disbursement of the fund. Lordship, kindly take the application first, Lordship.
I am for the secured case.
Lordship, this is my application for disbursal. Lordship, kindly come to page number 8, Lordship. Annexure B.
Annexure?
B. Page number 8, Lordship. Lordship, 6 August, date 2019. My claim has been adjudicated by the official liquidator, Lordship. This is the letter certifying that my claim of
Scrutiny of the affidavit of proof of claim against the company 425,000 4 crore.
Well, I am for the official liquidator. Lordship, there are only one creditor whose claim has been admitted by us and proof of date has been issued. That is my learned friend. They are entitled to. Apart from the income tax has not filed any claim. Other two unsecured creditors file their claim without any supporting document. So not been adjudicated. It's pending, they did not come. Only one claim has been adjudicated, 4 crores, and they are entitled to leave to your lordship. 1 crore 69 lakhs with our hand.
Lordship, selling movables and immovables.
And apart
company sum of rupees so and so has only been admitted.
Yes.
4 crore.
4 crore.
25 lakhs.
Presently in our hand, my lord. Lordship, report dated 19 December. Lordship.
Just a minute.
Presently in our hand, 1 crore 68 lakhs 85,700. 67,000 current account, other are FD. Apart from that, we are collecting 2 more funds. One is bank. Bank filed an affidavit, 1 crore, willing to file, my lord, reply of their affidavit. And another claim is admitted by ex-director. ex-director, two ex-director, my lord, filing their statement of affairs. They have admitted 47 lakhs and odds in their hand, cash in hand. Direction was given from the court to hand over the said amount to the official liquidator. We wrote a letter to them. They did not. Then letter for direction has been given. They have been arrested by the police. Came before this 30th. Justice Kapoor was there. They assured that they will cooperate with them, but they did not. Then order was passed to communicate the order to the that particular ex-director of the company. We communicate to the ex-director as well as the advocate record, but they did not turn up. So in this event, I am taking leave to file a further letter for direction as well as complaint matter. Otherwise, it is not possible to collect the money of the company in
You file it. Well, where is the leave is required?
One complaint has been filed. Second, my lord, within 2 weeks.
File it.
And my lord, direction.
What about this amount?
This amount, my lord, 1,68 lakhs with.
Where's your report?
Report is filed, my lord.
Last report is 19 December 2024.
Yeah, filed.
19 December 20.
Last page, annexure A, the fund lying with us. Only their claim have been admitted by us.
Page number?
12, page 12 to the balance. Page 12. 11, 12.
1 crore 68.
68. Out of which 67 lakhs, 6 lakhs, 70,000, 9 current account, balance are FD. Well, amount to FD, it will get interest. So I am leave it to your lordship some amount to them. And direction be given to file reply.
Bank SBI Barabon Road branch 1 lakh.
1 lakh.
And Canada Bank 4,000.
4 lakhs. Canada Bank,
Canada Bank Road 5,000.
PNB Brabon Road and
50,000.
Yes.
40,000, 50,000. And PNB Bourbon Road 1 crore 66 lakh. This is in which account?
Oh, all are FD account in the name of official in liquidation, in particular company in liquidation.
FD account?
Yes, FD account. But FDs create interest. We cannot unnecessary.
Correct. Where is the FD number?
FD number has not been mentioned.
Then
the number has what is FD?
FDR number is to be given.
Yes, Malad, that's true.
FDR, where is the FDR number? Or where is the details of the FDR?
With us, but not has been mentioned.
To file a fresh report.
Yes, yes.
By next week.
Next week.
Lordship, in the meanwhile, disbursements next week.
Let the fresh report become because the FDR is not there. When what amount will be released, then you will be in trouble.
Meanwhile, one direction, my lord. 2 weeks time to file the reply of their affidavit with the bank.
Where is the affidavit of the bank?
Affidavit they are filed.
You filed the affidavit?
Yes.
Where is the affidavit of bank? Which
1
bank?
crore with them. This
1 crore is with them.
Yes, they said that you disburse.
That amount has been received from by the bank before the liquidation was.
My lord, no. This amount belongs to company. So after liquidation, official liquidation is entitled to that amount.
How you got that amount?
In the SARFAESI application. SARFAESI says.
Okay.
Affidavit to it.
Lordship has
the record in the SARFAESI proceedings.
Yes, SARFAESI proceedings and that was
against the bank. Against the bank.
Against the borrower.
Against the borrower. Who is the borrower?
Rishi Art Limited and
so how the company is affected? How the company is affected? How the company?
The amount of the company now in liquidation, instead of director, the liquidator is there. So it property automatically will come to honor. They are saying another thing. Another story has come before your lordship.
Your lordship kindly.
Okay, you file the reply.
Yes, but 2 weeks, my lord. This matter be appear after 2 weeks since.
Leave me given to file reply also to me also in their application. The corporation been Union Bank affidavit.
Affidavit.
Doctrinal was the purchaser.
Okay, let the file reply.
In the sale.
Admitted. He's admitted. Lokhinah is the purchaser. We have purchased the company in liquidation. This is automatically.
Okay, let the reply come.
The application was also dismissed.
Official liquidator has filed the report disclosing the amount pending with the liquidator, but the said report does not disclose the details of the FDRs. Fixed deposit receipts. FDRs, full stop. The bank, Union Bank.
Yes, my lord, Union Bank.
Which branch?
New Alipur branch. Now it is in the assets recovery branch.
The Union Bank, assets recovery branch,
Kolkata.
Kolkata.
amount
has
is
filed
to company
affidavit.
liquidation.
Has filed affidavit after serving the same to the learned counsel for the applicant as well as the official liquidator. Learned counsel for the applicant and the official liquidator prays for time to file affidavit in opposition.
2 weeks, my lord.
Let affidavit in opposition file 2 weeks.
OL by 2 weeks. OL by 2 weeks.
2
And
weeks.
report, my lord, by 2 weeks.
The liquidator is also, the official liquidator also directed to file fresh report within 2 weeks.
Matter to be appear after 2 weeks.
After serving the copy to the learned counsel for the applicant, let the matter appear on 20th August.
13th August.
2020.
Lordship, affidavit direction has been given to me also, Lordship. Great. Great.
Next.
My lord, this is an interlocutory application in connection with a 10F appeal. My lord, in fact, this is the 10F appeal, my lord. I had mentioned, my lord, last week. Lordship had asked it to come as to be mentioned next week. This is an application taken out in that. Originally, when we moved it, my lord, in 2021, the judge said there's no scope for any ad interim relief, so please file your affidavits. My lord, I find, my lord, that affidavits are filed, but my lord, it's coming up after a long time, my lord, suddenly today. So, my lord, affidavit in opposition and affidavit in reply are all filed.
Already all the pleadings completed.
Yes, my lord. In fact, because it's an old record, we have in our record the copy of the affirmed affidavit in reply. We'll just check whether it's filed or not, but it's ready. And my lord, affidavit in opposition anyway was given. So, my lord, kindly post it someday later, my lord, for hearing, because the main 10F appeal, this is regarding the Ruby General Hospital, my lord, in Koshba. So there's a fight between two brothers regarding, my lord, a company dispute regarding that hospital. The main 10F appeal, Lordship has directed to come next week under to be mentioned.
That will come on next week.
Your Lordship, we had mentioned,
Okay.
Lord, your Lordship had asked the court officer to place it sometime next week. I don't know the exact date because it's an old 2015 10F.
What is the number?
It's APO 156 of 2015. That's the main appeal. But Lord, this is the order in
So
fact.
let all the application and the appeal will come on
Under to be mentioned, and then your Lordship can decide how to take it up.
on 13th August.
13th is fine, my lord. Your Lordship has said to be mentioned, then your Lordship can decide how to take it up. My lord, may it come on 20th instead of 13th.
Okay.
All of them together.
Counsel for the applicant submits that appeal being APO number 156 of 2015 is pending, and in the present application, readings have been completed. He prays for fixing the appeal along with the connected applications on 20th August 2020.
I'm so grateful.
In view of the submission made by the counsel for the applicant, let the matter appear on 20th August 2020.
Under the heading to be mentioned, my lord.
To be mentioned.
Great. I'm so grateful.
Thanks.
Lordship 9, this is at the application of the official liquidator seeking for some disbursement of the dividends to the Ministry of Defense. Lordship, the predicament is that some records are required still to be ascertained, your Lordship, and the claim though has been placed and admitted, but the entire claim could not be disbursed. So, my lord, I'm just praying for 2 weeks' time. We can come up with a present status and the report. We can file a report to that effect also, because whether any claim has been admitted, what is the status, we will come up after 2 weeks, your Lordship. If your Lordship.
Yes, you are the special officer.
That is regarding 60. This is CA 58. CA 58 is a separate application and CA 60 is a separate application.
CA 16 is 60.
60. There's application is CA 60.
Our application for discharge is CA 60.
Okay.
This is
And-
item number 9, your Lordship.
And in this case, what do you want now?
Lordship, I'm just praying for 2 weeks' time to file a report, because this is an application taken out at the behest of the official liquidator to disperse the dividends to the Ministry of Defense. But we couldn't. What is the position, your Lordship? That is the reason, your Lordship, we are praying for 2 weeks'
So
time.
you want to file reply? Report?
Reports so that the
My
entire
lord.
status can be placed.
My lord, if I may be allowed, my lord, my item number is 76 for the same company. I'm for one of the creditors. My admitted claim was around 76 lakhs, which was admitted. Thereafter, around 38 lakhs has been paid. The remaining amount has not been paid despite several reminders. Lordship, I've made an application for disbursement of that amount. My item number is 76.
Where is the application?
It is listed today, my lord, for the same company. It is
Item
listed
number?
76. If a report can be called for in that application also.
Have the copy?
Yes, it has been
Have
served.
you received?
Lordship, that I have to check, your Lordship.
76.
Lordship, we have received. I have got the instruction.
76.
Yes, my lord.
We have-
Rehabilitation industry.
Yes, my lord.
Justice Industry Corporation.
That is the company which is in liquidation.
Liquidation. And here is
Progressive Engineering, my client, my lord. Which is the
Nine-
creditor.
Item number 9.
Item number 9, my lord, is for the same company.
Correct.
My application,
Both will be taken
if
together.
put the then status
Number
report
9
would be
report. Item number 9. Counsel for the official liquidator. Press for time to file a report. In view of the submission made by the counsel for the official liquidator, let the report be filed within 2 weeks. List the matter on 20th August 2025. Police record item number 76. Learned counsel for the applicant submit that this is also connected with the same company which is in liquidation and paid for fixing both the matter together. In view of the above, let item number 76 bring IACA number 66 of 2025 in CP 5/2025 of 2005 be placed along with IACA number 58 of 2021 with CP 5/25 2005 on 20th August 20.
My lord, made me 27th, my lord. I'm not available till 24th.
27th, my lord. Then again before 20th, your lordship, that is fine.
I'm leaving on 7th, my lord, for
When you will be available?
from 8th to 24th.
When you are leaving?
28th, my lord.
8th
of August.
8th of August. And you will back on
24th, my lord.
27 you will not be available.
27th, there is a matter already fixed, your lordship.
My lord,
Before that, when
and he is going on 8th.
In September, I have no issue, my lord.
Okay,
My
3rd
learned
September.
friend will get some.
3rd September.
3rd September.
Both. 3rd September.
Grateful, my lord.
My lord, this is our application for discharge, and I have already bothered your lordship about my predicament, personal predicament. I have to give up my profession of 35 years because of my son, because he has to be constantly attended upon, and I'm not being cooperated upon by my co.
You are the special officer. Have you filed the report?
Special officer. We have filed a big report. All minutes and everything is there. Official liquidator was directed.
Have you served the copy to the?
Yeah.
Have you gone through?
Yes, we have.
Lordship, the report.
All these have been served, and exactly it has been served. The thing is that the papers are with my other joint officer, and since I have closed up my office, so he is not here, and I do not even get the information.
So who is the other officer?
Submitted.
Who is the other officer?
Shubhajit Raj.
He is also advocate.
Yes. He is also
not appearing.
We were appointed as advocate for the petitioner and official liquidator. At that point of time, I was appearing for official liquidator. That's why we were appointed, because official liquidator submitted.
So where is the other special officer? Both will come. Then I will set the official liquidator to go through the report.
Step into my place, because
correct. If it is your report is acceptable, then I will accept, and if required, then your official officer, special officer will be changed.
I have WhatsApp him some particulars to keep it available. That is also not there. No one is. It has been served. That I'm certain.
We have received that.
Yes,
it
is a long back
report, but it is not so bulky.
It is 16 January 2023. We filed this, and copy.
What is the good name? What is the name?
Mithua Sen.
Mithua Sen. Who is the other special officer?
Shubhajit Roy.
He is not appearing.
He is not. He is usually supposed to be represented by one of his junior, but most of the time he is not there. He doesn't answer my calls. I'm really in a miserable state, my lord. And it was submitted before your lordship at one point in time that I have expired. That is why I have to come in, and for me to come a single day is an effort.
Whether you are having an extra copy of the report?
No, presently
And
I have only my copy.
You both have submitted a single report.
Same.
Single
Joint
report.
The
Joint report.
Yes.
So you have to give the give the extra copy then.
I don't have my lord.
Not received. That is the instruction.
My joint receiver, my co-receiver said that special officer said that it has been served.
They are not received.
Historically, they have been served. Let there be another.
This is the report, your lordship. It's the sum of.
No, this is the application, and the report be filed subsequently.
You do one thing. You get it Xerox. get it Xerox. I am passing an order. Let the other special officer also.
I can hand over my copy. Let them hand it over, return it to my residence. Because for me, then you
President, then I will fix on the next week. Let you give the copy. They will get it Xerox.
Let that direction be on the other special
Correct.
officer because he has got the office.
Let the here. You give the copy to her. She will get it Xerox through the office, and I am fixing on the next week, and I will direct the other special officer to be present along with you on the next week. Next.
And they must make this available to me before.
Yes, they will get return to you. They will return after the Xerox.
I am handing over my own
That
copy.
week, if the matter can be fixed after week, because they are
Okay, I am fixing on 13th. 13th I am fixing.
I have got some personal difficulty for doctors.
When you will be available? 20? 20? Come on, 20.
But they must make it, take a stand to return it to my residence. They know very well.
Not residence, they will return in court here only. On 20th, it will be returned to you in front
Or
of.
if your lordship can kindly direct the Mr. Roy to, because he has got the establishment and my all papers are.
Let the Xerox it, it will hand it over to you on the next 20th to you, return back to you.
Let it be recorded that I'm.
Special officer. Mrs. Mithua Sen, Leonard Special Officer, one of the special officer is present.
Your lordship will kindly dispose of this matter after hearing us.
That the other special officer. What is the name of the other special officer?
Subhajit Roy.
Mr. Subhajit Roy is not present today. Is not present today. She submitted. Both the special officers have prepared the joint report and handed over to the official liquidator. Police official liquidator submits that they have received only copy of the application, but they have not received the copy of the report. Police stop. The special officer present today is directed to hand over the report, which is hand over the report to the London Council for the official liquidator, and the official liquidator and the council for the official liquidator is directed to get the same Xerox and to return the original, return the same to the special officer on the next date fix. Mr. Subhajit Roy, the special officer is directed to appear before this court on 20th August 2025.
Submission, your lordship will kindly.
2025 along with the special officer Mrs. Mithua Sen. Yes.
Your lordship can allow them one more week because why I'm saying there was direction to pass any objection if they have got to the report.
Okay.
They have not yet filed any opposition, not report. So if they want to, let them be ready with that on that date. And that should be served on me also.
In the meantime, the official liquidator is also directed. In the meantime, if the official liquidator is required, is intent to file exception to the said report, the official liquidator shall file exception. Let all the matter up. वो जो 20 बोला ना, उसको 27 कर दो. 27 you will not be available, na? Let the matter appear on 3rd September.
3rd September, but your lordship has directed them to file the opposition.
If they intend to file the exception, let them file the exception.
And serve a copy
And
of.
who will inform to the Subhajit Roy?
Subhajit Roy, I cannot because I can hand over my mobile. He is not responding.
Both the parties are directed
Official
to
liquidator
communicate this order with the request to Mr. Subhajit Roy to appear before this court on 3rd September 2020.
And a copy of the opposition or to the report.
That will be given on that day. You come on that day.
No.
Same company petition, I have an application which lordship earlier today I had mentioned. Lordship, make that application also appear on the return.
It's not listed.
Lordship, it is not there in the list.
What is the application number?
Number is 60 CA 65.
Give the list and they will give the list to my court office.
May it be. I will.
Okay. Come on 3rd September.
3rd.
This is my application. I am for the official liquidator. This is an application for auditor's appointment, lordship. Auditor's appointment.
Auditor's appointment.
Lordship, I am praying for an order in terms of prayer 1, 2, 3.
Where is your prayer?
Yes, Lordship.
Where is your prayer?
Lordship, on summons which I have annexed, Lordship. Will Lordship kindly come at page 3 of the summons for direction, Lordship.
This is a report.
Take it. I have a copy, Lordship.
नहीं है. अभी हम देखते थे.
Along with an application, Lordship. Your Lordship, kindly see CA 14.
Yes, yes. तो रिपोर्ट है. Yes, where is the prayer?
Summons for direction, Lordship.
Appointment of auditor
Yes, Lordship.
out of the panel to investigate into the affairs of company.
Have you Lordship got it?
It is your.
Oh.
As per the prayer made by the official liquidator, prayer A of the summons for direction is allowed. Full stop. The official liquidator is directed to file the report by 4 weeks.
Yes, Lordship.
Within 4 weeks, please the matter on 3rd September. Yes, that's it. Yes, next.
Lordship, this is my application. It's a very short point of law which is involved in this, Your Lordship. That there are several banks which have been involved in giving credit facilities to the company under liquidation. And these were all fund-based credit facilities as well as non-fund credit facilities, Your Lordship. The banks, those who had granted term loan, had a first charge over the immovable assets of the company. And the banks which had granted the working capital were given the second charge over the immovable properties of the company under liquidation. In a similar fashion, Your Lordship, where it came to movable properties, because it was related to movable properties, the banks which had given working capital were given the first charge and a second charge by the term loan. This was the short point, Your Lordship. What really inspired, Your Lordship, during the course of time, there have been various agreements entered into between the banks, inter se agreements, and I'll take you through those agreements also, Your Lordship. I'm just giving the background.
My Lord, before my learned friend starts, my Lord, actually I am, my Lord, appearing for also Indian Bank and UCO Bank and, my Lord, the Union Bank of India, my Lord. That is the respondent number 1, 3, and 4, my Lord. My Lord, this is the admitted fact. We are running late, my Lord. We have not filed affidavit in opposition. My Lord, there was a direction for affidavit in opposition. My Lord, affidavit in opposition is with me, my hand, my Lord. But difficulties, my Lord, clients are in the Mumbai base, my Lord, and they have sent the affidavit in opposition by affirming by notarial public, my Lord. But the annexure has not been the notarized, my Lord. So, my Lord, I was requesting this court, my Lord, ki I am serving today affidavit in opposition to my learned friend. And in the meantime, as soon as, my Lord, I am getting the notarized copy of the annexure, my Lord, my time should be allowed to file in a court, my Lord. And after submitting my affidavit in opposition, my Lord, any date may be fixed for the hearing, my Lord.
When the matter? 2023 matter. Still you are not filed the affidavit.
And kindly see the last order, Your Lordship, 12th February 2025.
My Lord. Any
is
date may be
clear.
fixed, my lord.
Affidavit.
I will serve in a course of the day, my lord, the scan copy, my lord.
Exchange of affidavit shall be complete on or before the
12th
returnable date.
February
In case of failure,
2025, there is a
it will be
deemed
deemed to be
order.
no affidavit on file.
There's
My
a
lord.
deemed order. They deemed that no affidavit is here.
My lord, we are admitting, my lord, we are in a delay, my lord. So kindly, our last opportunity should
Your
be.
Lordship, I appear on behalf of respondent number 2, that is Bank of India, and I have a similar prayer. Your Lordship, I shall file my affidavit in opposition. Kindly grants me 2 days time, Your Lordship.
Lordship,
Well, I appear
2023
for
application.
respondent number 5, my lord. My every opposition is there, my lord. And
It's served on.
is served on it, and I'm in fact supporting the contention of the petition. I'm supporting the contention of the petition.
Lordship, what has happened is this. At this moment, my learned friend
Okay, you do one thing. Where is your affidavit? And your colleagues are there.
My lord, my junior is there, my lord, but actually, my lord, I'm serving reports of the day, my lord. I will serve to my learned friend, my lord, and the time should be given to submit 2 weeks, my lord, 1 week, my lord, in a court, my lord.
Lordship, may I make an interim prayer in that case, Your Lordship? Kindly.
2 weeks. I am
Lordship,
fixing.
I'm just praying for an interim prayer. Lordship,
2023 till that no interim prayer. At this stage, come on 22nd, 20th. In the meantime, you file reply.
But Lordship, I am out of pocket.
Grateful, Your Lordship.
Okay, come on 20 days. Nothing will happen.
I'm only praying. Let this money be deposited.
Okay, no problem. Before puja, it will be decided.
No, Lordship, I am not before pujas. It should be decided in the next month itself, Your Lordship.
That's why I am fixing on
20th of August. It should be on top of the list, Your Lordship. Kindly keep it on top of the list.
Counsel for the respondent number 1 and defend number. Respondent number.
You're 5.
I am 5, my lord.
Counsel the respondent number 5
You heard.
an affidavit in opposition after serving the copy to the land counsel for the applicant. Counsel for the respondent number.
I am for 1,
3, and 4. 3 and 4. Submit that his affidavit is ready, and in course of the day he will submit. He will file the. He will supply the copy to the land counsel for the applicant.
Your Lordship, respondent number 2, Bank of India, may be granted the same leave, Your Lordship.
Where is your affidavit?
Your Lordship, I shall file it in a week's time, Your Lordship.
1 week I am giving. If you file, no, otherwise.
Yes, Your Lordship, I
The respondent number 5. Time to file affidavit in opposition.
shall. Yes.
Police. Consider the submission made by the counsel for the parties. The respondent number 2 is directed to file affidavit in opposition by 1 week after serving the copy to the land counsel for the applicant. The applicant is liberty to file affidavit in reply to all the affidavit in opposition within 2 weeks. The matter of 20th August 2025.
2-0, Your Lordship.
2-0.
I'm grateful. But Lordship, kindly have it recorded. It should be on the top of the list, Your Lordship.
It will come. It will come.
We've actually been suffering a lot on.
Only one submission, Lordship, on behalf of the official liquidator, pursuant to the directions of the High Court, Lordship, we have handed over the position to the Indian Bank. And
Okay, you file the report.
Yes.
You file the report.
I have already filed
File the report. Okay, no. If you file the report, I will see.
Yes, Lordship.
Sale has happened.
Sale proceeds of near about 28 crores, Lordship, is lying with the Indian Bank.
So there, what about the?
We haven't received. That's the whole problem, Your Lordship. We haven't received. They were.
What is
They
the?
came
They were
late,
wanting us.
Lordship, and we have filed our invitation.
Give your claim to the
application.
official.
That is also pending before Your Lordship.
Okay, let come.
The money is.
You disclose all the things in the report.
Yes, Lordship.
Lordship, Indian Bank was the lead bank. And
There is
the
no
money has
report.
been
I think
distributed by
report is
lead
there.
bank.
Report है file में. Report है.
February 2025.
Liberty to given to the respondent number 1, 3, and 4, my lord, to file a wakalatnama and affidavit in department. My lord.
February 2024, there is one report, Lordship.
No report is
And
there.
another report we have.
No report is there. Only 24 January report. Only 24 January report is there, madam.
24th January report is there. Another report is number 6 February 2025.
We've been only.
Okay, you file a fresh report.
Because we have only been served with one report, Your Lordship.
In the meantime,
which is this is 24th January.
Official liquidator is also directed to file a fresh report.
Which is the other one?
After serving the copy to the applicant.
This one I have not filed.
To the parties.
Lordship, may I once again pray it should be on top of the list. Otherwise,
it will be there. Don't worry.
My lord, My lord, respondent number 134 should be given a liberty, my lord, to file affidavit in opposition in department, my lord, before next returnable date, my lord.
File it, file it.
My
Lordship, in case if they don't file their affidavit, it should be deemed to be have been treated
That's
as.
why let you take you. It will be given to you today. Yes, call the list.
Grateful, Your Lordship.
13, my lord, is my petition. There's some urgency in the matter, but my lord, Mr. Bachawat is leading me after the pre-lunch matter, my lord, he gone.
My lord, we have filed an application for demerral, saying that, my lord, this court, there is inherent lack of jurisdiction.
He takes order, my lord, from this court. After that, it stops having jurisdiction, my lord. But those
He
will
takes
have
order.
to
I
be
take order in 2011.
70.
Obviously, time has changed after 10 years. The clock has not stopped. And
No,
I'm
but
not
those will all have
I'm
to be
not the
taken up, my lord.
legislature. I'm not. We do not draft the laws. We only
No,
show the
those
laws.
will also
So what you want?
next week, my lord. Next
week.
Wednesday.
And next Wednesday, my lord.
Shudu Wednesday, Wednesday.
Lordship only take Wednesday, no? Can it be on Friday? No.
Friday come in the original set. Non-commercial.
No, it can be a
Non-commercial.
company.
As per the prayer made by the counsel for the applicant, let the matter
Applicant in CS7.
applicant in CS7 of 2025, let the matter appear on 6th August.
Lordship, kindly allow me to appear on the virtual mode in case I cannot make it.
Not trusted anybody to appear in the virtual.
Grateful, extremely grateful.
My lord, only one clarification, my lord. Next week, my lord, the applications will be taken up first, my lord, or the final hearing matters.
Application. What is the application?
Because
What is your application?
No, my friend is asking regarding the 10F appeal which is going
The
on.
10F appeal
That
is
is
taken
why
up, my
asking.
lord.
Okay, no, that I will fix the matter.
Okay.
Before that will be fixed at 3 p.m.
3 p.m.,
Before
great.
3 p.m. all the interlocutors will be taken. Yes, call.
And well, there was only one other, my lord, order to be passed in that matter, my lord. Affidavit of service be kept on.
First fine. Affidavit of service be kept filed by the applicant be kept in the record. Yes.
My lord, appear for the RP, my lord. That home buyer matter, my lord.
I thought I thought Mr. Bose has changed the advocate.
Anyway, they have taken everything. So whatever is left, I think he's taken the rest.
15.
Yes.
My lord, the basic facts first.
One thing before Mr. Millard, my landed senior starts. Millard, one thing, Millard, we had sought for Millard clarification before your lordship's court, Millard. There were two petitioners, Urundhati and Aniruddha. Now, Millard, what I find, Millard, now they give their appearance only on behalf of one petitioner. Now, Millard, we had pointed out to your lordships, Millard, a month back, that they should, Millard, point out and submit to your lordship that for whom they are appearing, either for two or one. So that subsequently, it is not said that I am not heard. Well, let them clarify that before proceeding. Otherwise, one will come after 1 month, say that I have not been heard.
I have not been.
That is a fantasy of law.
That is, but Millard, if they can clarify, Millard, then Millard, we can avoid that.
He has both of them.
I'll just find out, my lord. Hello, my lord, the advocate on record is on his way. But we'll find out and tell them during the course of hearing. My lord, basic facts first, my lord. My lord, Notobot Dotto Properties Private Limited. My lord, this is a closely held family company of the Dotto family. Three brothers originally were the original subscribers of the company, having equal share. Three. And this is a land holding company. Several lands were purchased over the years in the name of the company. Now, my lord, there's another aspect of which I'm not troubling your lordship because that is not the issue in this application at least. Well, there's a debenture issue that I'm not troubling your lordship now. Now, my lord, what happened is one of the brother applied before this court for voluntary winding up. Not by a creditor, voluntary winding up. So on the application of one of the contributory, which is one of the brother, my lord, a winding up order was passed. My lord, cutting the long story short, thereafter the company went into liquidation. Orders were passed from time to time, in terms whereof, my lord, the orders were challenged, appealed, everything. My lord, the properties, most of the properties have been sold, and the proceeds have come to the official liquidator. Some of which has also been distributed to the legal heirs of the original contributors. 3 brothers, so their line, in the original line of succession has become, they have died long back. So these are the successors of the original contributory. So they are the heirs. So they are entitled to the to what proceeds have been generated, because the reason is, well, there are no creditors in the company. No creditors. No statutory dues, no statutory creditors, no financial creditor, no operational creditors, nothing. So, well, it comes back to the contributories. Now, at this stage, my lord, one branch, my lord, I'll trouble your lordship with that branch only. Your lordship will see there's a genealogical table.
Page 60 of convenient.
Lord, if your lordship takes the convenient compilation which has been handed over. Yes, I completely agree with. I completely agree with.
Volume 1, page 60.
It should have been just a compilation. They have used the word. Should have used the word inconvenient compilation. But my lord, with a heavyweight on the other side, they possibly thought better to annex everything.
Yes.
Openly petition.
তুমি আমার কম্পাইলেশনটাকে শেম করে দিলে। Now, kindly take the genealogical table once.
Page
60. But opening that 60 is also quite an effort. Genealogical table.
Yes.
Kindly give me a moment. Your lordship will see. Kindly take the one on the left, which is Yudhishthir Datta. That's sufficient for our purpose.
Yes.
But here your lordship will find the first wife and the second wife.
Yes.
My lord, we represent, my lord, your lordship will find Arundhati and Aniruddha, which are the son and daughter of Anima.
Arundhati, Anima, yes.
Yeah. Arundhati and Aniruddha are the son and daughter of Anima. And thereafter, if your lordship takes Anima and Robindranath, they were the children of Kamala. Now, Lord, Kamala was the first wife of Yudhishthir.
Anima is the daughter and Rabindranath is the son of Kamala.
My lord.
Correct.
And my lord, Yudhishthir had the first wife. They are the children from the first wife. And my lord, your lordship will see immediately on the right hand side below Yudhishthir is Bhanumati, which is the second wife. My lord, here Kamala and Bhanumati. Kamala is the first wife and then the second wife. Is your lordship found that, my lord? These two. So my lord, there are 2 lines. They belong to the second line and I belong to the first wife. They belong to they are the heirs of the second wife.
So they are from Bhanumati.
Yes, they are yes, they are the children from the second wife.
Correct.
And I am the heirs of the children of the first wife.
Correct.
This is the point. This is the issue. Now, my lord, Yudhishthir died leaving behind the will. The original Yudhishthir. The Yudhishthir. Yudhishthir died leaving behind the will. Now, my lord, here at this stage, my lord, the will was challenged. My lord, a caveat was filed by Robindranath and Anima. That is the son and daughter of the first wife. Right. However, probate was granted.
Who is the executor in the will?
The executor was Otonu.
Okay.
On whose behalf my learned friend appears. So basically, my lord, it is a fight of the estate of Yudhishthir, because Yudhishthir has 1/3 share, and like the other two brothers, so he had 1/3. That is not in dispute. So the question is that who will get that 1/3? Now, my lord, here what?
Why
Now
1/3?
probate was granted.
Why 1/3? There are four.
No, there were three
Yeah,
contributories.
as per your list, 4. As per 4.
Yes, the one died without leaving behind a will,
One died.
or without leaving behind any successor, died a bachelor. So that devolved upon the other brother. So it became 1/3 each. The original structure of the company, whatever that there are original 3 contributories. So they are the heirs of the 3 contributories. So now, my lord, if your lordship will see, Yudhishthir died leaving behind a will. Will was probated. Despite caveat, it was heard contentious cause, probate granted. Now that probate, that grant, my lord, went up in appeal. Now that became a reported judgment. But I just wish to trouble your lordship once with a few paragraphs from the reported judgment. My lord, this reported judgment which your lordship will find. কম্পাইলেশনটা কোথায় গেল? কাল যে জাজমেন্টটা দিলে দেখি জাজমেন্ট পেয়ে গেছি। This was reported in 1999, volume 1, Calcutta High Court Notes, page 35. আগের দিন দিয়েছিল।
No, Supreme Court. That is.
Oh, yes, of course. Well, the Supreme Court comes after this. Well, Lord, kindly take the second paragraph. The case concerns kindly take the first para as well. My lord, concerns the grant of probate of the will of Yudhishthir Datta. My lord, your lordship is found that, my lord. First para.
Yes.
Yudhishthir Datta, then will has been executed in such and such. Code below probate was granted to the propounder being the executor Bhanumati, the second wife of Yudhishthir. Then sometime in the 30s, Yudhishthir's wife died, leaving behind surviving son and daughter, Robindranath and Anima, which is on whose behalf, who are the 2 caveators. In the late 30s, Yudhishthir married his second wife, Bhanumati, such as such. 15 years thereafter, he had a son, daughter, such and such. That is Otonu and Arupa. Then, now kindly come to para 6. Robindra's sister Anima also lodged a caveat. First, Robindra lodged a caveat. Then the Anima sister also lodged a caveat. Phone ta niye na. Then, my lord, kindly come to কোন প্যারাগুলো ছিল? My lord, kindly come to
Ramadatta. Kindly note, that's an important fact, not by Anima.
इनको वापस कर दो, डबल कॉपी दे।
The appeal was by Ramadatta, not by Anima. Kindly,
my lord, kindly see the appeal, Rama Datto and others, not just Rama and others. Right. Now, my lord, kindly come to para 14, 1-4.
Background suspicion, fraud.
Para 14. Has your lordship been given the SCC online version? Then our paragraphs will tally. The situation, my lord, does the para start with the situation is? Therefore, a classic one where the stepmother might well wish to exclude children of the husband of the first wife. It is to be noted that we do not say that this must necessarily be the case, but we do say that it is a practical and reasonable possibility of which the probate court should not lose sight altogether. Now, my lord, the interesting part starts. Now, my lord, your lordship will kindly come to para 39.
Yes.
we feel deeply suspicious about this case run by the propounder and her son. There are two main reasons for this suspicion. Then, my lord, don't trouble your lordship with no need to trouble your lordship with the suspicion. Then, my lord, kindly come to para 40. Another pointer to the possible knowledge of Bhanumati and Otonu, which are the from the second wife, prior to Yudhishthir's death of the will, Exhibit E, it is a document signed by Yudhishthir in March 78. It is most peculiar document. This is addressed to nobody. It states that Yudhishthir has no connection with his children by the first wife. The lack of connection is so much that after Yudhishthir's death, the children by the first wife will not even able to utter Yudhishthir's name. The document also says that there will be no alteration in the will. This document comes from the custody of the propounder. It was proved by Otonu. Only one question was asked in examination in chief. That proved the document. No question was asked on this document in Otonu's cross-examination. Such and such was shown. Then, my lord, kindly take para 42. Court is left in this most unsatisfactory state of mystery in regard to Exhibit E. If the propounder had known of Exhibit E when it was signed, that is in March 78, she would have read about a will. She might have asked Yudhishthir about the will. Why Yudhishthir should be inimically disposed towards his daughter by the first wife as much as towards his son by the first wife is also not explained. Again, that is the tenor of the document. The court might well suspect on a practical and ordinary view the matter that the stepmother wanted a written declaration of animosity against her two stepchildren by Yudhishthir before his demise. The fact might be otherwise also, but no explanation has been. Then the caveatrix onima.
Mr. Bose, just
my lord,
who is in the 3 p.m. matter?
3 p.m.
Mr. Mukherjee, only 15 minutes will be there. Will you continue?
Whichever date, my lord, after.
I am giving. Let me continue on next Wednesday at 3 p.m. Both the party convenience.
Could it be 13 then?
13th of September, August.
It's a Wednesday.
Record an order. Item number 6, huh? Item number 6.
5 and 6.
5 and 6. Due to paucity of time, hearing could not be taken. The hearing could not be taken place. According case adjourned, let the matter appear on 13th August at 3 p.m. 13th as 3.
My lord, could it be 2 to 3, my lord?
Okay, another 2 p.m.
2 to 3, my lord, after
2 p.m.
Right. Great.
Yes. Sorry.
Yes, madam. The caveatrix, onima, para 43, came to the box. Although Robindro was not shown Exhibit E, onima was. She vehemently denied that there was any reason why her father should declare that she has no connection with him and should not even utter his name after his death. We have found no cogent reason why Exhibit E should be taken as a voluntary writing of Yudhishthir. Yudhishthir expressing his own hatred against his own daughter, Onima. Since document mentions a will, we feel a mystery to be existing as to whether this document gave Bhanumati and Otonu and idea, should be any idea, that there was a will, and whether they got this idea quite a few months before Yudhishthir's death. The case law regarding grant of probate is reasonably well settled. Mr. Such and Such, appearing for the respondent, relied on the judgment of Viscount Haldane and delivered in the case of Such and Such. He said, so on that basis, that once it is proved that a will has been executed with due solemnity by the person of competent understanding and apparently free agent, the burden of proving that it was executed under undue influence rests on the party who alleges this. Mr. Such and such submitted that execution and mental capacity being beyond challenge, Rabindranath had to show undue influence of Bhanumati. Mr. Such and such said that there was absolutely no positive evidence in this regard. He gave us also to Supreme Court. In first of these cases, the aged testator had totally disseminated. Then, my lord, kindly come to para 45. Mr. Ghosh, for appellants, gave us first case Carapiet reported in 60 Calcutta and showed the paragraph where it has been said that the probate court will jealously examine and scrutinize the circumstances of execution of a will. He then gave as a root case of Tyrrell, that this is, my lord, that 1891 All England report, and placed the judgment of Justice Lindley. He said that the ratio and the guidance laid down here has been followed again and again. The rule is that wherever circumstances exist which excite the suspicion of the court, and whatever their nature may be, it is for those who propound the will as to which the suspicion arises to remove such suspicion or doubt and to prove affirmatively that the testator knew and approved of the contents of the document. So it was upon the propounder. We have noted passages from Tristram and Coutts on probate relied upon by Mr. Bachawat to the effect that the will cannot be said to be a voluntary will if the mind of the testator runs in this way, like I do not want to do this, but I must. Mr. Ghosh cited several other cases, and then, last of all, a judgment of Sir Ashutosh Mukherjee delivered in the case of such and such, reported in 25 Calcutta Weekly Notes. Again, in this judgment, there are indications here that unless a well-grounded suspicion of the probate court is dispelled, probate cannot be granted. Applying these cases and also drawing upon our own experience, we might say a few words about the practical law of probate, grant of probate. Without troubling your lordship much, I'll come back to this, what happened in this case. In our case, para 48. Yes. Now skip kore gela. In our case, execution and mental capacity are beyond question. We therefore are compelled to ask ourselves whether in good conscience we can grant probate by ruling out the challenge of Rabindranath and Yudhishthir did not freely and voluntarily bring about the will in 1971, but that it was a result of poisoning of his mind by Bhanumati. If we are in two minds, if we think that Bhanumati might well have done it by her persuasions and pressure during the 6 days which elapsed between the previous contemplated will and the will in question, which is sought to be probated, if we think that we can reasonably suspect on the basis of the presence of Somarendra and the peculiar exhibit that Bhanumati and Atanu knew of the will from the very beginning, but also pretended ignorance of it, so that the burden of the involved beneficiaries is not cast upon them. If we are in two minds about these points of major importance, then we cannot say that the mystery and suspicion attendant, suspicious attendant, I think this is it should be, upon the will sought to be probated have been completely explained away or removed. The original boita ache. I think this SCC has got printing mistake. I'll just give you a lot of CHN ta dao to. CHN ta esche. I'll just correct. Page ta bolo to 35. अरे 77 दिल. अरे 77 CHL दिल. My lord, I come back to this, my lord. I was.
48. 48.
Last 5 lines. If we are
Yes, if we are in two minds, in short, as to whether Bhanumati did or did not influence the mind of Yudhishthir in the matter of bringing about the will propounded, if the possible involvement, persuasion, or pressure of Bhanumati might reasonably be suspected to be present and not explained away as absent altogether, then, and in that event, we cannot in good conscience grant probate. In our opinion, in this case, we cannot in good conscience grant probate. Then, my lord, your lordship will kindly take once page para 56. Now, these are the reasons, my lord. Your lordship will see the reasons why he's revoked the grant.
There's a problem.
yes.
Para 56.
No, problem is there.
There's a problem in the paragraphs also.
We agree that the revoked millet has been revoked.
Okay.
No, it was millet.
No, of course you do. But they don't have a choice. This is the judgment of the division bench.
We admit.
Well, the question is that, my lord, if you admit that it has been revoked, now, my lord, kindly see the reasons why it has been revoked. Suspicious circumstances is the reason for revoke. So the appeal court said that this will of Yudhishthir was a suspicious document. Suspicious circumstances, the will goes. What happens after the will? I'll just show you. My lord, kindly take the last paragraph. What happens? My lord, kindly once take para 58. Your lordship doesn't have 58?
Starts from?
It is at the Bagbajar residence.
Yes.
That Exhibit E was executed.
Yes.
That's the will. Exhibit E does not show that Yudhishthir was doing everything on his own volition. Why should he then make out that his relationship with Onima was embittered beyond repair? It must therefore be concluded that if Yudhishthir was under Bhanumati's domination in 1971, which might well have been the case, he was under the same domination of his second wife in 1978, the year of his death. Thus, domination in the usual course suspectedly went on increasing as the years passed. If the case is otherwise, the propounder should have shown it to court or at least given enough indication of it by adducing cogent evidence. Instead of doing this, she herself stayed away from the box. Lordship, kindly make a note of this. And there is a compromise based on this. So, my lord, and the
Court was not given an opportunity to assess.
The court was not given an opportunity to assess if her personality was of a domineering type in the witness box, where she was not seen by anybody. However, we must also remember that had Padda Khastugir as now seen in the personality of Bhanumati and yet reserved her judgment for 5 years, not much impression of it would remain with her in that event. Well, that was the judgment of the single bench. Then, my lord, limitation is pointed out.
61.
Then, my lord, kindly take 61. The case was heard in the court below for some 20 days. We have heard the appeal for 6 days. The appellants will be entitled to the cost, such and such. The appeal is allowed. Judgment decree appealed against is set aside. Probate is refused. Letters of administration refused. So, what is the effect, my lord?
Gone.
So, goes back to the natural heirs.
Equal.
So, whoever are the natural heirs in the line of succession of Yudhishthir, I am one of them. Now, your lordship will kindly take what happens in the Supreme Court. Lord, kindly take volume 2, page number 226. I'll just trouble your lordship with, my lord, what had happened is, now the appellants before, today there's a full court reference. Sorry.
There is two things. Milad, he has to clarify, Milad, either for petition number 1 or 2.
Yes, of course, I will.
Come with the instruction on that.
Yes, of course, of course.
Number 2, Milad, kindly, Milad, head this out, Milad, if possible, Milad. I know, Milad, the schedule of this court, Milad. Any other day prior to Wednesday on, Milad, if with this pace, Milad, this goes on, Milad, it will be difficult to complete it, Milad, with having one day.
Test match.
Peace.
Not T20.
No, I accept, but Milad, give it some precedence, Milad, any day, Milad.
Yes, sir. I am hearing. And Learned Counsel for the your applicant. What
Yes, sir. Applicant in CA 27.
Then Milad, applicant means both.
Applicants of CA 27.
Yes.
For the applicant in CA 22. 157.
22. CA 22.
CA 22 of 2017 and argued at length, but due to paucity of time, hearing could not be completed. Let the matter appear. आज कितना तारीख है 30 है on 6th August at 3 p.m.
Milad, kindly, Milad, if he is attending for both the applicants,
He will inform on the next day. He will inform.
Yes, I will.
The counsel for the applicant of CA 22 of 2017 shall inform this court on the next date fixed.
So he has a reason to be bothered.
Whether he is appearing for both applicant.
We'll inform on the next.
Both applicant or one applicant.
Well, just one indulgence. Well, item 55 and 56, the interim order is required to be extended. Well, that's the Avni matter. Well, transfer. That the point that I argued, Ms. Dalmia is on the other side.
Refused. Next time ना ये वाला जो है ना क्या नाम उसका अवानी वाला इनको सब ऊपर कर देना उनको खत्म कर देंगे.
Well, the interim order is required to be extended. Well, in CAT.
दोनों सब एक साथ कर दो. 50.
Well, in item CA 83, Lordship sees well, CA 83.
54 and 50.
Well, the item 55 and 56, yes.
55 and
54.
Well, like, interim order is only in 55.
55.
55 में करो. Counsel for as per the prayer made by the. You are for the.
Well,
I am for the applicant. Well, in CA 83.
The interim order is extended till 13th of August 2025 or until order whichever is earlier. The matter remain in the list.
Well, it is fixing on 13th of August. But can it be on?
No, matter will be remain in the list. Extended only 13th. And next.
Grateful.
On 6th of your all matters will come up.
On 6th. But I'm in some difficulty.
Okay, the other matters I will take. Then this will be taken on 9th.
Very well.
Very well. Grateful, Lord. Grateful.